Are present, and Commissioner Buskerud from the County Board is representing the board today. Approval of March 23rd minutes.
Mr. Chair,
Karen.
I have a correction to make, please. On the minutes, item number 5, Planned Unit Development Review PU 0607. This is for Cimarron Mobile Home Park. Condition number 4 in my motion, I believe, should read that each mobile home shall have a minimum 20-foot separation between living spaces. And number 5 should be amended to read that decks and/or porches be allowed with a building permit as accessory structures to each mobile home and are not considered living spaces unless they are enclosed and have roofs. Laura, you seconded that motion.
Yeah, and Mr. Fairby called me and asked about that, and I concur with what you say, yeah.
Okay, cool.
Any other changes, corrections, additions to the meeting minutes? If not, I'd entertain a motion for approval of meeting minutes with that correction, those corrections.
So moved?
Second.
Motion second for approval of meeting minutes. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Opposed, same sign. Meeting minutes are approved. Approval of the agenda, and for the audience, the agendas are in the back bookshelves if you haven't picked one up and wish to have one. When we approve the agenda, it's with the consent items, and we'll first go to the Planning Commission to see if any staff, I guess, any changes in consent items.
Staff would like to pull off number 5, please, for a change of condition.
Thank you. Anyone else other on the Planning Commission that wishes to have any of the consent items other than number 5 pulled for discussion? If not, PJ, if you could read items 3 through 8 excluding 5 for the record.
Did you go through the paragraph yet?
Pardon me?
Did you go through the paragraph information yet?
Not yet.
Okay, I'll read it.
Go ahead. So.
The following items have been placed on the consent calendar for action to be taken on all items in accordance with staff's recommendation by a single vote. Any item may be removed from the consent calendar by any planning commissioner, staff member, or audience member for a separate consideration. The findings of this planning commission are recommendations to the Pennington County Board of Commissioners, who will make the final decision. Item 3 of the consent calendar, conditional use permit review 1403 for Homequist Incorporated. Mike Harmon is the agent. To review storage units to be located in the subject property in the Highway Service District. Staff recommends approval of the extension of CUP 1403 with 8 conditions. Item 4, conditional use permit review CU 1405, John and Lori Burl, Black Pine Distillery, to review a home occupation to distill alcohol spirits located in an outbuilding on the subject property in General Agriculture District. Staff recommends ending conditional use permit 1405 with the applicant's concurrence. Item 6, conditional use permit review 1303, Philip and Colin Hunter, to review accessory structures, wood shed, and greenhouse without a principal structure in a limited agriculture district. Staff recommends ending conditional use permit 1303 with the applicant's concurrence. Item number 7, road name Osprey Trail for Jim Skull, to name a 66-foot wide private access easement providing access to the properties, and staff recommends approval of the road name of Osprey Trail. Item 8, construction permit 1507 for Shane Schreiner to grade and stockpile dirt for construction project located inside the city limits of Hill City. And staff recommends approval of construction permit 1507 with 7 conditions.
Is there anyone in the audience that wishes to pull items 3, 4, 6, 7, or 8? And again, we'll be approving the agenda with the consent items. Staff would like to move item 13 at the end of the consent items. So it'd be, we'd have an item after consent, we'd have items 5 and then go to 13 and then proceed down to 9.
Correct.
And that's for staffing at the upstairs planning desk, just to assist us. So with that, I'd entertain a motion for approval of the agenda with the consent items.
So moved.
Motion and second. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Opposed, same sign. Motion to approve the agenda and consent items is approved. Item 5.
Item 5, conditional use permit review 1411 to review a family cemetery on the subject property in a general agriculture district. What staff is looking to do is amend condition number 3, which reads that this conditional use permit reviewed in 3 years or on a complaint basis or as deemed necessary by either the Board of Commissioners or the Planning Commission to verify that all conditions of approval are being met. Staff would like to take out the words "in 3 years" or "on" and just have it read that this conditional use permit be reviewed on a complaint basis or as deemed necessary by either the Board of Commissioners or the Planning Commission to verify that all conditions are being met.
With that change, I'd entertain a motion for approval of item 5.
So moved.
Second.
We have a motion and second. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carried. Go to item 13 then.
Hi, good morning. This is Kelsey Roush, Planning Department. Item 13 is for a conditional use permit to allow for vacation home rental and general ag for Ken and Corey Tomovic. They they went to change the name of, and they changed who the name was for the property and did not realize that the CUP would be automatically revoked if they would have come and applied to review the conditional use permit prior to changing the name on the property. We would have been allowed to just continue it and it would be fine, but we did have to revoke it. There were several pages missing out of the staff report that you should have gotten stapled. I did find a couple of issues regarding the number of overnight guests. I found several inconsistencies in the staff report and several of the things reviewed in the last conditional use permit. I did, in the last page of the stapled document is the letter from the state DENR verifying how many people can stay based on the septic sizing. They allow for the maximum daily flow of 240 gallons per person, or per day, which is equal to 60 gallons per person per day. So that would only equal 4 people. So the maximum amount of people that can stay overnight is 4 people. Do we have any questions for me?
Questions for staff?
We did not receive any letters or any calls from neighbors or anything in opposition to this, so.
I guess this was briefly touched on at the last meeting, but the staff have a concern of it going to basically a corporation where the underlying ownership could change and yet the corporation wouldn't change, and it kind of circumvents the intent of the rules of change of ownership, triggers a review.
Yeah, it does, because they can change who's underneath the LLC whenever they want, which does go around our, our ordinance, but there's really nothing that we can do that I know of, so.
Might this be a matter for the state's attorney's office?
Yeah.
To look at?
Tinsley, you want to comment?
Tinsley Grote from the state's attorney's office. Well, it's just, I guess at this point, up to you whether you want to allow that, knowing that the underlying ownership of the LLC can change and the property won't be automatically revoked if that underlying ownership changes, or basically it changes without coming before you. There's no review that's needed if they were to change ownership. That's the biggest question, is whether you want to allow that.
That's kind of my concern with the vacation homes being reviewed right now. That may get changed, and I mean, I can understand the reason, you know, that the Tomovics would want to do that just to protect your estate. I mean, you see that happening, you know, on ranches and things like that too. So I mean, but it certainly does kind of take away any review, future review of change of ownership, underlying ownership, so. I guess Ken and Corey are here, applicants. Do you wish to, any comments or?
Sorry, I'm late. I didn't think this would.
We shuffled the
Be-
agenda
it
on
was
you, sorry
fast.
about that, so.
Simply that the only reason we did this was that our attorney said for liability reasons that we should be under an LLC. As far as the future, it is a family-owned. I don't think that it's ever going to be transferred to other owners. So could you give me your real questions? I mean, because this has been in operation already. It's successful. There's not any problems with this property being.
And that's, I guess, not the question. I think it's more the precedent that we're setting, that anybody with a vacation home rental could now form a corporation, and they'll never have to go through another review by change of ownership of the underlying corporation, because the corporation hasn't changed, and that's what the legal paperwork shows, that corporation, and yet you could change all the ownership underneath that corporation.
Well,
And-
the committee is reformed right now.
Right.
We meet this Friday, and those issues of transfer are up in the air as far as what those precedents are going to be, or whether somebody can transfer. In all the other zoning districts, from what I understand, it's okay to transfer property. Is that correct? Transfer a CUP. The CUP stays with the property in all other zoning districts other than suburban residential. So.
But we're
what-
general.
But this one is general ag. So I don't understand
Well,
what the problem is.
I think to me, it circumvents the intent of the rules. And I mean, there's a lot of discussion when we went through the vacation home rental process, and you guys were,
Yep, we've been
part of
there.
that. There's a lot of back and forth on, do you trigger review with every, vacation home rental transfer of title? And, the decision was yes, but this kind of takes that away. And it may be that with the rules being reviewed, it may come out that, and I can see that, because I mean, like you're saying, it's, essentially a business, you're protecting yourself from liability. If you want to pass it on your heirs, it's easier to do under corporate. There's a lot of positives to that, but there's also, it circumvents some of the intent of the rules. I guess, PJ, or you look like you have something to say, so.
Well, just want to clarify, like Corey said, the committee is meeting this week, and we don't know what the change or if any changes are going to occur. But as the ordinance sits now, the town of Victor are doing what they're required to do in that zoning district.
Right.
Because it is general ag, it has a lot less restrictions than SRD vacation home rentals do. And so staff really doesn't have any concern with this.
Okay.
Could we add a condition on this that after the committee settles this issue, which I assume they're going to do, that this would be reviewed again?
My concern would be on timing for them, because I mean, I'm sure you want to be running things out now.
Yeah.
And the committee, you're probably 6 months down the road before the final rules.
That is correct. And what we didn't understand that when we had a different title, that it was actually a transfer, because it's the same people, we're the same people that own the property. And so we didn't understand that that was actually a transfer until this last November, when we were told that it is. So we are trying to do the correct thing, and we came in and now we got it revoked, our CUP. We're asking basically your permission to continue our operation that so far has had no problems.
Well, and I'm not questioning you. I guess it's more, the question is to the precedent we may be setting. And I think this planning commission is supporting you, otherwise we wouldn't have recommended waiving the
Yes,
fees.
thank you.
So, and I think we realize that your location is unique, and it's probably gonna stay in the family a long time.
Yeah, that's the plan.
So,
Mr. Chair,
Right.
again, I say, have this approved today, but with an additional condition that once the committee, that is reviewing the vacation home rentals comes to a decision on this particular issue, which is certainly going to come up now, that this would be open to review again.
Mr. Chair? Can I say something too? And in fact, I don't claim to speculate what the committee's going to say, and determine, but one of the things that did come up in some of our other cases or our other situations was that we wanted to make it easier for people to transfer stuff. So the formation of an LLC may be one of the things that allows people to do that. So I would be concerned about speculating on how that's all going to end up and not put additional conditions on this particular permit or this particular conditional use permit.
Well, that's the question I guess I'm
Yeah,
raising.
we
is
don't know.
We don't know, but at this time, it does give them a tool to circumvent the rules as they stand right
It
now.
makes it easier. Yeah, I have no problem with making it easier to transfer.
Mr. Chairman, before it was revoked, whose name was the conditional use permit in?
Their names.
Your names?
According to
Well,
Ken's,
the
yeah.
conditional use permit, the property was originally it was my mother's and my name, and now she's in assisted living. And the conditional use permit was in Corey and myself in our name. So the CUP was in the two of us' name.
So we're trying to change it into the LLC now?
Correct.
Before the county commission does really change these rules? Or at least looks at changing them?
Yeah, they're working within the new change that occurred earlier this year. They're working within those rules right now.
Is there any reason that we should deny this CUP based on the creation of this LLC, according to the ordinance?
No, I guess I'm just raising the question because it is setting a precedent until the rules get changed.
Yeah,
Personally, I'm not opposed to their application. It just, to me, it is raising a concern.
Well, I appreciate that, and I think it's good that we do, but I think that's something to be left for the present committee that's going to review the ordinance and may change it in the future. But I think we simply have to do what's necessary at this point. We've alerted ourselves and others to this, and I think we now have to approve this, assuming all other Ts are crossed and Is are dotted. So I can't see any compelling reason not to approve the Tomovic's their vacation home rental.
I believe you have another speaker that wishes to speak. You want to come forward and give your name.
My name is Jeff Roller. I live, my lot is just a stone's throw from the property in question. This was one of the concerns we had, was this very thing happening, that someone would form a corporation and then this wouldn't be, we've been living in the Strata Bowl for 17 years. And we fought hard, as you all know, and I didn't perform very well. I apologize for that. A lot of lost sleep. This has changed our lives dramatically. We used to drive by to the rim of the Strata Bowl, and there would be, if we'd see a car up there, we'd go, oh, somebody's hiking into the Strata Bowl. Now we're surprised when there isn't a car there, anywhere from 5 to 10. There's not even room for all the cars that want to park there now. So continuing this into a corporation, my question would be now, if it's a business entity, can you sell that business entity? Even though it's staying in the same name, now you have a continuation where a conditional use permit, by my thinking, was always, well, this is going to be a temporary thing until something changes. So now what you have is you have someone living in one residence and having two conditional use permits of homes which they do not reside in. Takes a lot of properties eventually out of the market. Changes the hotel structure in town, changes the tax basis and qualifications for that type of thing to run basically a hotel out of a home. There's huge fights going on in California, even San Francisco. It's been going on now since 2011. And it's just, it gets to be a bigger and bigger fight with more and more issues. Being able to transfer this as a business, it just means to me like the 17 years we had of total privacy is gone forever. Now, the other thing we have going on with this particular conditional use permit, and I've tried to address it, and I can't ever seem to get some sort of qualifier. But under this conditional use permit, I've tried to point out that the Strata Bowl is unique in its name alone, and they've attached this to their corporation now. So now what you have is the power of the internet, their own personal websites, the Strata Bowl itself. So now you have a cumulative effect. And that's what I have been seeing. And so now with social media, somebody goes up and they take a picture. They're taking a picture of me sitting in my chair through my windows. I'm listening to those people do the very natural thing as if you're standing over the Grand Canyon. It's a small Grand Canyon, granted, but what do you want to do? You want to yell, see if you get an echo, see what happens. Then you get the unsavory characters love to throw rocks off the top. So it's just a continuation of what used to be the most blissful home in the Black Hills, the most private home, to a situation where when I drive out, I had a medical emergency a week ago, packed up my bags, had to go help somebody in distress for a week, and here I am, and there's people on the top. I'm packing my bags, leaving the house, and wondering, I wonder how many people on the top saw me doing that, going, what an opportunity. It's just not like living in a cul-de-sac anymore, where you're in West Rapid in a cul-de-sac or something, when you have people coming visiting their neighbors or whatever. This is becoming a commercialized area in a residential area. You can call it suburban residential, which is part of it's general ag. And so it's becoming quickly a total commercial operation. And the fact that they're changing it to Strata Bowl vacation homes is just more precedent saying we're going to advertise the Strata Bowl. A little bit worried about the code of conduct here. I just talked to one of the other property owners, just bought land and building a home on the top of the rim of the Strata Bowl. He was unaware of this action. Apparently, was there a meeting about this particular thing at the last meeting?
It was on the agenda previously.
The agenda? I wasn't made aware of that. I have some copies of my letter that came with my notification certified. If I could, I only have 5 copies, but if I could hand those out. If you read that, you might want to take a minute and read that, but when I read that, it doesn't look like much is going to happen today. I don't know if that was deliberate or not, but my understanding of reading the code of conduct for an official on the committee meeting is such that one of the code of conduct qualifications is you are supposed to be concerned for the residents affected by the conditional use permit. That letter really does not point out the severity and the longevity of the decision you're about to make today.
I guess,
upset about that.
let me back up a little bit. I mean, some of the things you're pointing out as what's happening on the rim, I don't believe is in the control of the Tomovics. And so, I mean, please address, pertinent to the facts. And like the other thing, PJ, as I'm aware, there hasn't been a complaint filed, so the only action is what's described there as a change of name.
Yes, and
so, I mean, there isn't, without a complaint filed, that isn't formally part of the process today.
Yes, and my complaints were the same complaints I made before the conditional use permit was granted. And so they're just an ongoing, I mean, if I felt that it was going to make any difference, I guess I would have filed more complaints. I'm just reiterating what the past was, only the severity is ongoing and getting worse. As far as the Tomovics not having control of the effects of their advertising, even on their websites, they give directions to the top of the best view of the Strata Bowl, and they give directions to come into the top. All the search engines, you type in the Strata Bowl, all of their business entities are there. The Strata Bowl Weddings, the Strata Bowl Vacation Homes, the Bee House, ongoing and ongoing. And it's only going to get worse. Social media is a very, very powerful thing. I'm not sure if people are unaware, but this is going to change our lives forever. And having 2 vacation rental homes and an annual balloon event, all you have to do is look to what started in Pappy Hoyle's backyard this year. There's no room for all the people that are coming. Albuquerque, New Mexico. That balloon event did not start with 300-400 balloons and 50,000 people. But we have a seemingly blanket coverage for the annual balloon event tied to the
I'm giving you a
CUP.
lot of latitude, but I mean, you're addressing items that are not part of their CUP.
But when I was trying to get the annual balloon event pulled out of the CUP, all I heard was Ms. Tomovic saying it's just 3 days. And I know for a fact that the ongoing thing is there's going to be more and more people knowing about the Strata Bowl through that. Now, if I can hear today that the balloon event can be pulled aside and be separated and not a blanket coverage for that. And the other thing with the CUP for a vacation home rental, adding the weddings is another whole business. So you've got 3 ongoing businesses that feather the nest. And so those are my concerns. I think it's outside the scope of a conditional use permit for just having 1 home, but when you're building a 3-business entity,
Questions
all
for Mr.
collaborating
Oler?
together.
Questions for Mr. Oler from the Planning Commission? Thank you.
Can I say one more thing? I would like to request, until I can get a hold of the other landowners, Greg and Jennifer Lean, and visit more with Jeff Hoffman. My request is that this conditional use permit be held until the final rules are recommended from the new meetings that are going on right now under the conditional use review. I request that for Jeff and Roberta Roller, and until I can reach the others, and I haven't spoken with potential owner of our additional lot that will be affected from my brother-in-law. So, if you set up a rules committee, I don't see any reason why I can't wait until those rules are forthcoming.
Thank you. Anyone else wishing to speak? Corey, Ken, do you have comments?
If, I don't know if I should respond or not. That house had 130 nights rented last year. That means that there was less traffic, less use, less people on the road. In our perspective, the vacation home rental gives the residents more privacy down in the bowl. The balloon flight, you're right, is not part of this. It's an event. It's a separate piece of property. The weddings, we've only had 1 wedding since this, and there were 11 people. And our intent is, I think we're getting painted as people that have a really malicious intent for our properties. And I would say that the opposite is true, that we are trying to do the best for our property and our family and the neighbors. And he talks about the Hoffmans up on the top. He did not contact them, but we have contacted them in the last 30 days. They do not have a problem with this. As far as Greg and Jennifer Leon, they are shareholders in Bonanza Bar property. They voted that this was an okay CUP, and we have been in contact with them in the last 2 weeks, and they do not have a problem with this. So that's my only rebuttal. We are trying to operate with the best practices in mind, and proof and evidence of that is that we participate and we are at the table in all of these committees to make sure that this is done above board with the county's involvement at all levels. And so I think the proof is in the pudding of our operation. There have been no complaints.
Question for Tomowicz?
Can I make a comment? And
Sorry.
just refresh my memory, you guys live down there too, right?
Yes.
Okay, I thought so, but I just want to make sure.
Any other questions for Tomowicz? Thank you. Anyone else wishing to speak? Right now, the staff's recommendations for conditional use permit 1504 with 16 conditions. Anyone wishing to offer a motion?
I would move that we adopt approval of the 1504 CUP.
I'll second.
Motion and second, further discussion. Hearing none, all in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carried. I would comment, I guess, to Mr. Roller, if you feel like you have a legitimate complaint, I mean, the CUP is renewed on a complaint basis if you feel like you have a legitimate complaint, but then we have to notify that in the hearing documents too, so. But today's action was basically for a title change, so. Thank you. On to item 9, I believe.
Good morning, Brittany Molitor. Item 9 is construction permit CP 1508 for the Summer Creek Road District. It's to install a culvert on the north end of Summer Creek Drive to improve portions of Siskin Loop and Carbon Loop and to grade and maintain other existing roads within the district. This was brought before you guys in November of last year, and you had directed the applicant to separate the construction activity between what was being done for the road district and what was being done on private property. So the applicant has come forward with 2 separate applications to indicate which parts are part of the road district and which parts are part of the private property. You can see on the map above that the areas in the orange are part of the private property. The items in the blue and the green are part of the road district. The items in the green are grading and maintenance of existing roads. And typically, in the past, our office has not required any construction permit activity for regular maintenance of roads within a road district. In addition, the roads within the road district are, excuse me, considered private, so they don't fall under our Ordinance 14 standard requirements. That is indicated on their plat also. Excuse me, that area that is closer down here to Taylor Ranch Road, down here in the blue, that's where they want to do a culvert installation in addition to putting in a water line. There is one issue with this road district that we had found. This road right here, this new construction road on Siskin Loop, in previous maps, it had shown a section line going through here, and it appeared that the section line was running here. I worked with Register of Deeds, and we had determined that actually the road is in the section line right-of-way, so that would require, and this is where the road is, and it currently is, already had material put in there without approval from the Board of Commissioners. So because of that, we're asking to continue this construction permit until they can get approval from the board to construct this road within the section line right-of-way. But if the Planning Commission does want to move forward with the construction permit, staff is recommending 13 conditions. So if there's any questions.
Brittany, where's the section line in this? From the other picture, it looks like.
It is
the section
actually
line-
this property line right here.
Yeah, but back in the picture where it shows the Forest Service sign,
The Forest Service sign,
there. That is on a section line, isn't it?
yes. So, and I'm assuming this pin right here is the section line, because here's the Forest Service boundary. I have talked to the Forest Service, they do want this material removed and they want it
So the section
revegetated.
line actually runs left to right across that
No,
that
this is
picture?
the section line right
No,
here.
across that picture.
Yes, it runs, yes, eastern, yeah,
Okay.
it runs this way.
So there's actually about 3 feet encroachment onto the section line.
And the Forest Service is
Well-
aware of that, and they have, spoken to the applicant, and they are working to get that material removed and revegetated. We did look at, here's the original plat from 1960 that shows this as a section line, that property line. So if you have any questions, I believe the applicant is here.
Brittany, I guess, maybe clarification, or maybe I'm reading too much in between just the way that it's written. It's, staff comment, roads with the exception of section line road are located within a road district are not subject to ordinance 14 standards and do not require engineered road construction plans. I'm looking under subdivision, our rules, and under design standards, this isn't ordinance 14, this is
The subdivision?
section 500.
Yes, but this property was platted in the 60s, and those roads were put in the 60s, so our subdivision regulations were not in effect at that time. If you look under, and I know you can't read it in here, this owner certificate, it does dedicate those as private roads. The only road that is not, that is public is this Summer Creek Drive, and that road has already been constructed prior to our requirements. So, and I had talked to the highway department in length about that. Now, if this would have been platted at a different time, then it's my understanding that they would have had to follow the subdivision regulations. But since they do not, and they're a road district, they wouldn't. The only road that would apply is this one within the section line right of way. That's my understanding. I guess Kinsley could.
Well,
Speak
I guess my question
different,
is, it's, one thing, ordinance 14 addresses roads that are gonna be on the county system.
Right.
But then section 500 references design standards, and to me, if the road was never fully developed and it's just being developed now, it would come under the rules when it's being developed, not when it was platted. I don't, question.
Sure, and that would, I would believe Kinsley would be the better
Yeah.
person to answer that.
Because, it's kind of saying we're ignoring safety rules, if you're saying it's not under, design standards, and that's what we're here to do, is protect the public and public safety. And if you're saying all standards are thrown out and you can do what you want, and yet you're gonna sell these lots to the public, that's where I'm kind of
Sure.
struggling with that.
Sorry to put you on the spot.
I don't know if I can answer this question. It might take a little bit of research, so, because it's, when, do we consider it when it's platted versus when it's actually developed, is the
Yeah,
question, right?
that's, I guess, if the rules are set when it's platted, you're right, it's probably, you can't talk about our improvements, but if the improvements have never been made, truly made to reestablish, or establish that road until now, it seems like you'd go by the rules that are in effect now.
I don't know if I can actually answer that one off the top of my head, though. I'd have to look into that one and see
Look at me.
what the answer would be. Sorry.
And I guess the only other thing that came up was this approach here with the DOT. They would have to get that approved through the DOT, that area there to get onto 385.
Questions for Brittany?
I believe the applicant is here also, so.
Can I ask one question?
Sure.
So what you're saying is that even if the ordinance requirements do not apply to these roads because they're private roads, you're still requiring a construction permit just for the portion of the section line road?
No,
Or
the
for everything?
the disturbance, because even if they're building the roads, they still are disturbing that 10,000 square feet. So
Okay.
it would still require the
So
construction
that
permit.
still apply? Okay.
Yes.
Okay.
Yes.
I just wanted to clarify that.
Just not the standard of the road,
It's not the road standards,
except for in the section line right away.
the section line. Okay, thanks. Brittany, how much work have they been working on these roads prior to this construction permit? And one of the letters that we got in the packet said there was a stop work order. Was that really the case? And did they keep working? I'm just curious about how this has all happened.
Sure. We've been out there on several occasions, and it doesn't appear that the roads are built. The road within the section line right away was constructed without a permit, without going to the Board of Commissioners to get approval for that. I'm not sure if they were aware that was a section line.
I just found it, honestly, within the last week or so with the Register of Deeds. Because if you look at the aerials, it doesn't appear that that's the case, but it is. But they have been doing some work. And going into the next one, there is some areas of private property here where they're doing some work here. They also have a building permit for a structure that they're building here. And in our ordinance, it does allow them to do some site disturbance without a construction permit for the purpose of the building. So there's kind of three things going on here on this property. So it's just kind of trying to understand which parts are associated with which parts. I have been in contact with the applicant and with others out there almost every day. So,
Mr. Chair.
Lori.
And when this first came to us, you said in November, wasn't this all like one big thing? And you guys said, well, that's not the way this should be done? It was
Correct.
one big permit?
it was all under one permit, and it was actually, you guys had made the motion to come back.
That it was
You denied it
confusing.
without prejudice,
Yeah.
correct, and then you had them come back and separate out the work.
Okay, and also I have one other comment. I did have a telephone conversation with Mr., I can't see your name right, Evangelisto, yesterday, so,
Okay,
just so everyone knows.
okay.
Mr. Chairman, I have a question, Brittany. It looks like your two concerns are the construction of the road within the section line
Yes,
and the approach from the DOT.
correct.
And their conditions of approval already listed, and you, I mean, if we would approve it, you said there's 13 conditions, and number 1 addresses the section line, and number 10 addresses the approach. So what is the difference between approving it with those conditions and continuing it till May? It's just who does the work? You or us, the commission? Or-
Essentially, as staff, because there's a violation, because there was work done without a permit, we can't recommend
Sure.
approving it.
No,
So
I
that's
understand, but really, in practicality, there is no difference.
No. I mean, it's just up to you guys whether you want to approve it or not.
I mean, being on the commission, it'd be much easier for me to say, well, planning department, figure it out, and then bring it to us, instead of having us try to figure it out when they apply to the commission for the permit.
Right, and one of them would be letting them, move forward with their work with the understanding that they do have to go in front of you to get the section line work, or making them wait till they get approval from you. That's basically the two differences. It's just as staff, when they have a violation, we typically don't allow any work to continue until that violation is cleared. So that's why there's the two instances, that if you guys decide that, in good faith, that they're going to do these things, you can let them move forward.
I can't say I'm really anxious to let them continue with the work before the commission approves it, because that could be a waste of money, but, okay, thanks, Brittany.
I guess, Brittany, I just have one other comment, maybe, and this is more generalized but we keep seeing this comment from the Forest Service that they do not recognize section line right-of-way on National Forest Service system, only on private property. And yet, I've heard comments from former County Commissioner Ken Davis that this was discussed in DC, and the Forest Service did admit to section line. I guess I'd like to see a clarification. We keep saying that comment, and just saying it doesn't make it true if it's not true. And I guess I would like to know, instead of us seeing that comment, if it's not true, I'd like to get that clarified at some point in time.
With the Forest Service?
Well, yeah, I mean, maybe back to Ken Davis, and he said there's meeting minutes from a meeting in DC where the Forest Service did admit that section lines are under their.
I don't know if I'd go
recognized.
that far, but.
No, that's the information I was given.
No, I was a part of that. And yes, if the state's attorney's office looks through some of my files from 25 years ago, they will find a letter that they don't necessarily admit that one way or the other, but they dropped all the issues that we were having with them at the time.
Okay.
So they basically said, yeah, you're right. And it goes back to when South Dakota became a state and how they accepted the land out here and how we rededicated some of the Black Hills to the feds. And it was a complicated mess But somewhere, there's a letter that explains all that, I think, unless when I left, they threw all my stuff away, which I wouldn't have blamed them for, but.
Well, I appreciate that, Ron. But I guess, like I said, we keep seeing that comment, and just,
And it's complicated, and I'm not sure there's a definite answer yet. but-
okay.
Right.
Thanks. Anyway, the applicant's here, I believe, wishing to speak, and I also did receive a phone call from him. I suggested making the points here today at the meeting, so.
Good
it was
morning.
limited
I'm
discussion, so.
Dan Evangelisto, I'm representing the Summer Creek Road District. As of the last fall meeting that we had to split things apart, from that point until last Thursday, I wasn't aware of that. It had to go before the county commissioners to be approved. I thought it was just gonna be another one of these meetings, and then we were gonna move forward. Prior to work being done on that section line, I didn't know it was section line. Obviously, I would like you to recommend approval. I don't have any intentions, obviously, of working on the Siskin Loop on the section line right away or the other approach issue at this time. I have no intentions of working on that immediately. However, a more pressing issue is installing the culverts on the base of Summer Creek Drive. Summer Creek Drive is probably a little over a quarter-mile long, has 200 feet of elevation change, and in the past 2 summers, we've had major surface water runoff down the ditches there, and that's the reason for installing. We can't keep the roads in place on the west side of Summer Creek Drive at the base because of the volume of water coming down. So we'd like to install these culverts, hopefully as soon as we can, because the rains are going to be coming soon. And the water main extension, I would also like to be able to do that as soon as possible, because that water main will support the construction project that is going on Lot 10 and 11.
Mr. Chair, can I ask a question? Where are you at as far as getting your approach permit with the DOT?
I was issued an approach permit by South Dakota Department of Transportation already, so I don't know if they're aware of that or not.
Okay,
So I already have that.
so then are you saying that condition number 10 is not necessary, that you already have the approach permit?
I would have to verify that it's still valid. I have one in my binder that was issued already,
Okay.
yes.
Has that been provided to planning
I
staff?
would think you would want to show Brittany
They
that.
never asked for it. I
Okay.
haven't given it to them.
Okay.
Last meeting we had, I did state that I had that, and I was never asked for it, so.
Okay.
Yeah, but at this.
Since
our-
it's
our-
suggested as a condition, I would suggest
Okay.
providing that to staff.
Our road district was only formed just a few years ago. We don't get a lot of money in the road district, so it's not like we can come and do all the road improvements at one time. So that's why we're doing just a little bit at a time as funds come in. Basically, since it was formed, the money's just been going into a checking account until we built up some funds that were sufficient enough to do something substantial at one time. And that's been this last year or so.
Okay.
Chairman, if I could answer Lori's question. I did receive a email from Rich Zocker, one of the engineers at the DOT, on March 30th, and he had indicated to me that the road section on the south end would require an access permit, so I'm assuming that they don't have one
Okay.
in place, and it does not meet our current 1,000-foot spacing requirements, but would be allowed should there be positive results from an engineering study, was his comment.
On that same note, the reason I'm not in a hurry to put that approach in is because they also told me we had a sight distance problem looking south. And as far as I know, the Department of Transportation has been doing studies, and they're thinking about widening parts of 385. And we had a community meeting at Johnson Siding Community Center a few years, 2 or 3 years back. And I was talking with the people that were in charge of that what our intentions were of putting that approach in that was platted. And if we could work with them when they do that road widening so they can take care of that site issue. When I made application and received permit for that approach, the highway department has basically told me I didn't need anything special. I could actually go out in the highway right away and clear trees and material out of the ditch to make the site distance.
So,
So I guess I want to clarify too that we're talking about the approach is off of 385.
correct.
But you want to do the culvert install off of Taylor Ranch Road. So I think I was confusing two different things. You have two different approaches there. Okay.
Yeah, absolutely. There's actually 3 approaches into that little plat.
Okay, where's the
2 off
third?
of 385. There's,
Oh, there's 2, okay, all right.
and then there's Summer Creek Drive, which comes up off of Taylor Ranch Road.
I only see one on 385, but
Yeah.
I'll take your word for it.
They're both carbon looped. It comes around on both ends, the north and south end of that plat.
Oh, okay.
Oh,
But you have approach permits for both of the approaches?
2 of them already in. The third one has never, ever been put in.
Oh, okay, okay. Oh, this would be probably the third one.
well, I think there and then here.
But he said.
3 off 385 or?
2 off of.
2 off,
385.
okay, okay.
And then the
okay,
third one
and
was here. So
That
you
was
got one.
Taylor Ranch Road, okay, all right.
Nice.
Oh, yeah, that's an existing one, okay.
Other questions for Mr. Evangelisto?
No, this.
You have further comments, or you finished the?
This is just
Kent,
what he
go ahead.
wants to build this.
Good morning. My name is Kent Haig. I'm an attorney for the Evangelistos in Summer Creek Inn. One of the things I wanted to clarify to the commission is the section line issue with the road in it and debris running off and so forth.
That's road district.
Again, as was already stated, they have
Hey,
talked.
excuse me, we have a speaker,
They have discussed the matter with U.S. Forest Service and they are working with them. One thing that was important to my client, so I don't believe you had stated yet, is that section line road was already cut in long ago. It existed a long time ago. My clients, I think, bought the land approximately 10 years ago, and it was in a long time before that. What they have done is they've graded, maintained, and added some material for the proper crowning and grading and things like that. So just so it doesn't look like they're cutting roads when they didn't have proper permission or anything like that, that's not the case.
Are you saying it's been formally opened, that section line road has been formally opened?
It existed
Previously?
before, yeah, a number of years, as I recall.
Sorry, excuse me if I could. When I looked at aerials from Rapid Map, the older ones, there wasn't a road there, so that was the reason why. I can pull up Rapid Map.
Lot of the roads.
Is there any record that the county board formally opened that section line road?
No, not in our office. Jerry and I looked through our construction in a section line, but that doesn't necessarily, but I can pull up Rapid Map.
If I could, most of those roads when I bought that property,
Yeah, into the mic,
most
please.
of those roads when we bought that property hadn't been driven on for years. So they were there, but they were grown over with grass. So if the aerial doesn't show it, that's one reason possibly why.
Brittany or PJ, I guess, correct me, I think there's a difference, though, is if there's a 2-track on the section line road, or it's been formally opened by the county.
Correct. If you
Yeah.
formally build a road, I mean, it's a right-of-way, so people can use it to cross it and get places, but if you actually construct and put material in it, then it has to go to the board for approval to open that up. All there. That's what I was using.
Prior to us buying it, Baker Timber and I think it's Ron Johnson, owned a lot of this property and did some clearing and thinning before we did some clearing and thinning in there. And I think Baker had a lot of big equipment in there too, and he had done some road improvements prior to us buying it, years before we had bought it.
Any questions for the applicant, his attorney? I guess the staff recommendation is to continue this and, but I mean, motion, then we go to the floor, so.
There's other individuals here that would like to speak to this, make comments.
Well, I was
Oh,
going to
you
go
wanna
to
wait
the
till the
motion and then
motion?
open it
Okay.
during discussion
Okay.
for the audience, so. I guess, well, let's go to the questions from the audience then first, and then we'll come back to a motion, but wanted to keep the discussion pointed to the motion. That's the intent of.
My name's Gary Briggs. I own a house up on,
One speaker at a time, please. You could sit down and just, when your turn to speak. You don't have to go back to the back seat. You could just sit there until he finishes. Thank you. And please state your name for the record, so.
Gary Briggs. I own a home up on Bullock View Lane. It's actually 12799 Taylor Ranch Road. I had bought property in the subdivision prior to the Evangelistos, so I'm aware of what the roads were like. What he's calling that section line road was a trail, a two-lane track. He went up there and with his equipment, he expanded the road. And I know this is coming up on the next one, item 10, but in order to get rid of the spoils from the construction that he's doing, he's been taking those spoils and he's been trying to jam them, cram them anywhere he can. One of the areas where he took a lot of those spoils was up on that section line. He crossed over, you can see that he almost, in fact, I went to the Mystic Ranger Station in Rapid City and I informed them what was happening. I told them if they didn't get up there soon, not only if they wanted to find their National Forest sign, they'd need a metal detector because he was burying it. He's crossed the line, he's on over the section line, he's on Forest Service. There are going to, on the next item 10, we're going to talk about some other areas that he's used to bury his spoils. But this is the road district. So there's a lot of us here, members of the road district. They have the books. We can't see the books. We don't know where the money's going. We don't know what's being spent. He's asking for culverts. Now, and I can see why he needs culverts. When he did all his excavating and land improvements for this hypothetical pavilion that he's building, he probably has a 200-foot-long access to that area. And it should have been culverts underneath that access, but there's not. So now if I were to, let's say if I buy a lot up there and I want to put in a house and a driveway, it's my responsibility to put that culvert in. Not the road district's responsibility to put the culvert in. I'm doing the construction. In my opinion, he should not be charging the road district to put all the culverts in for his improvements. That's not part of the road district. And the other, he destroyed the roads in that area with he uses a dump truck, a Caterpillar, excavators, tractors. He's been hauling this dirt, and I've approximately 45,000 cubic feet of dirt that he scattered around this area. He's hammered the roads down. He's right. The water does run down the road now. It has no choice. The road was hammered down. There is no crown to the road anymore. So the road district was supposed to maintain the road. That's why we wanted a road district, for maintenance of the road. He's refused to do it. He's always said, oh, I can't find a road grader. Even though I found a road grader for him, gave him the phone number of the road grader owner. He said he couldn't get gravel because the gravel pit was closed. He's always found gravel when he wants to gravel his parking area or anything in front of his bed and breakfast. But there is no gravel for the rest of us, nothing. So as far as this road district is concerned, we need to see the books. We need to know where the money went. And if he wants to put a culvert in for improvements to his property, it should be out of his pocket, not the road district. Thank you.
Questions for Mr. Briggs?
Mr. Chair, can I ask a
Yeah,
question?
Lori? Mr. Briggs?
Yeah. Could
Good
you
question.
point out where you live? Your address is off of Taylor Ranch Road. Oh, it's way in the back there?
Andy,
Okay. Okay. Oh, you've got, okay, all right.
I'm down here. I'm up here. Now,
Okay.
since we're talking about roads, that brings up another question here. What he says he's got a permit from 380 to put the approach on 385. I was told by the highway department that they would never allow an approach there because you're coming down a hill, around a curve, and it just was going to be too unsafe. Granted, it was set up that way as an emergency escape in case a fire comes in from the north. But from what I heard from the highway department, they did not want that approach there. So, what he's saying doesn't jive with what I've heard.
Okay, thank you.
Other questions for Mr. Briggs? Thank you. Go to the other speakers first. Dan, I'll come back to you after we've given everyone else a chance.
My name is William Newcomb. We bought property in there just 2 years ago. And we have never, basically, the only mention of the road district up there was through the Evangelistos. Just after we moved there, they mentioned that they had a road back up in the back. But our tax money is going to this. We've never had any meetings with any road district. Don't know of any staff on the road district, presidents or whoever. And they're pulling tax money off out of my taxes to maintain something we actually don't even use any of that property back in there. Our property borders the Evangelistos and National Forest. And we use the Taylor Ranch Road coming out. But my understanding is if he's the head person on this thing, all this work should be hired out. He shouldn't be, he's not the one to be doing that type of work. He should be hiring those people, somebody else to come in and do that type of work. Go ahead.
I'm Donna Messer. I'm Bill's wife. We are in the very corner down there where the words Taylor Ranch Road and that section line, we're in the little blue square. Like Bill said, we've never seen any books. We weren't even apprised of this meeting other than neighbors saying, the permit application had been made and that we would have an opportunity to speak. So there was no certified letter, no notification that improvements or changes were coming, and we've watched him dig the side out of the hill to try and, try and come up with his hills or the leveled area for item number 10 that'll be coming up. And like Mr. Briggs said, all of these spoils, all of the drainage, all of the crowning of the road has been ill-managed and unaware, and neighbors unaware of his overall plan of action or you know, what is the ultimate improvement aspect that he wants to achieve? And there's just been very little communication. They've not lived up to giving us notification of what kind of things are going to be happening in
The only
in
road
area.
base that he's been putting down up there are the spoils from his excavation for this pavilion that he wants to put in. He's not using proper road base for a road. Those roads, they're just not going to last. Any of that work that he's done up there is just, it's a waste. It really is.
And it's a waste of our money that's going into the road district. Because he'll turn around and say, well, you owe me, you know, because I've done the work and I've tried to, you know, maintain and do this and that, but it's not properly done or adequately done to service the drainage, to service the watershed, and to, you know, for the infrastructure of a building to withstand. So that's.
Questions for Bill or Donna?
Chairman, you're not going to like this, but, and you might want to run it by the state's attorney's office, but the county and the county commission has absolutely no authority over a road district. They are a separate political governing body. And whether, I'm not disputing anything you say, I'm just saying we can't tell them how to build roads or how to spend money. Not to say he's doing it correctly, but we're the wrong people to go to. Maybe if you have a complaint, you might want to see the state's attorney on misuse of funds or something in a public entity, but we can't. I mean,
Understand.
the idea of he's not building roads terrible, you know, may be true, but I don't think there's anything we can do about it, and you might want to.
I think some of our issue is the drainage of it. You know, I mean, and his
that we might have
stockpiling
something
and
to
his
do with.
changing of heights and not being able to crown properly, and the materials used affect that drainage, and it affects watershed all over the
I don't know.
subdivision.
County may have something to say about drainage. I don't, except the drainage on a road that's in a road district is going to be a touchy situation.
Understand?
Mr.
A question, you may not know the answer to this, but is Taylor Ranch Road part of this road district, or is that part of the county system?
To our knowledge, it's part of the county system. The actual Taylor Ranch Road is part of the county system. That's,
And your lot is
we're lot
on
number
Taylor Ranch?
5, yes. And
That's-
Yeah, we're lot number
we're
5,
just east of,
right where
is there
the
a-
sign says culvert installation.
Yeah, that's your
That line
lot.
point, we're
yeah,
just to the
this-
left of that.
Okay.
So you
Hang on just a
you don't
moment.
even access
We
the
are,
road district then from your lot?
this is our lot, well,
There you go.
this
right
is our
there.
lot right here. This is,
Part of the
this,
subdivision.
and this is our lot right here.
Yeah.
We border Summer Creekian and National Forest.
National Forest.
Okay, that's what I was asking.
Brittany, did you have a clarification? And then I think Barbie, you had a question?
Yeah, I have a question.
Let's go to Barb first.
But the road district, the county accepts a road district, and then anything within it, is that a civil matter? Or who oversees the road districts? I'm just not
Basically,
clear.
the board of the road
Yeah,
district.
It's a separate political entity, and they have, theoretically, they elect the board of directors to run it, and
Yeah.
they have the authority to tax, and,
The last road district meeting that this supposed road district has, that Daniel says he represents, was held in May of 2013.
So is
Prior-
anything then within a road district a civil matter? That was, I guess, my question.
Essentially,
well, yeah, I guess. I mean, theoretically, I suppose there could be criminal matters too, you know, but it's like the county commission, if we start using money that we're not supposed to be using, and yeah, there can be criminals, but mostly it's a civil matter, yeah, sure.
Brittany?
Chairman, I just had a clarification. I did talk to our drainage engineer regarding this property. He did have some concern with drainage coming onto Taylor Ranch Road, hence the reasoning for the culvert. And he did have some concerns about what we call water quality capture volume by him doing this disturbance, that he's creating more drainage that's going on into the culvert, so that, or going down onto the ditches on Taylor Ranch Road. So the drainage engineer has commented on that. And typically in the past, our stormwater manual does say that you can't increase the drainage coming off of your property through construction. You have to maintain it or divert it or retain it somehow, so the historical drainage doesn't change from your construction activity. So that answers questions.
And I assume there's been no plans submitted as far as detention ponds or retention ponds?
No.
Okay. Other questions for Bill and Donna? Any other speakers?
Good day. My name is Robbie Clausen. I live on Carbon Loop up there. And I kind of just want to echo the same comments that Gary and Donna and Bill already said. And like Mr. Buskerud said, it's not really a Pennington County matter, but when I talked to Julie Pearson, the state auditor, or the Pennington County auditor up there, she said that Dan can't be working on the road district since he's the president of it. And he can't be paying himself to go out there and work. So I just wanted to bring that up. And it just seems a conflict of interest for that. And then like Bill and Donna said, there hasn't been a road district meeting since 2012. So I went down to talk to Dan in February, and I said, hey, you know, I asked him about the road district just to try to get some insight, and about snow removal and the grading and maintenance of the roads. And he said, yeah, you'll get a letter in the mail. We'll have a meeting here shortly, and there still hasn't been a meeting. So I also talked to Julie about that, and Julie said the road district meetings need to happen every Tuesday of the May, second Tuesday of May every year. So I'm still waiting for a letter of notification for that, for a road district meeting on the second Tuesday of May. So, and then kind of just like Mr. Briggs said, he's taking the shale and spoils off of his property up there, the one that's the big orange hectagon, and he's putting it on all the roads. My road comes south off of Carbon Loop up there, and when I moved in there, it was just a fire trail, four-wheel trail. Yep, and then that's what the road right south of my house looks like, and you cannot take your Honda Civic or whatever through that. I got a Jeep, and I've never driven on that road. Nobody's ever driven on that road since I've lived there, so. You can't drive up there without a pickup or a Jeep or anything, so. He's taking the shale from his construction site and dumping it on the roads. And I don't know how that works, but shale, from my construction experience, doesn't compact well, so. You would actually need some clay-based dirt or the quarter-inch size rock to make a base for it. So I still don't understand how his designs for that road are. But I just wanted to echo the comments again about the road district of him being the president and paying himself to work on it. But even though Mr. Buskerud said that, you know, that's not your guys' problem, but.
Mr. Chair.
Yep, Lori.
Mr. Clausen, could you point out what lot you live on?
Lot 8.
Do you have him on there? Okay. Up in here?
Oops. This one, correct?
Yep.
Thank you.
Other questions for Mr. Clausen? Thank you. Anyone else wishing to speak before we go back to Dan? Okay. Was there anyone else? Just want to make sure I've got everybody covered before I have you. Okay, thank you, ma'am.
Hi, I'm Nancy Evangelisto. I am the Secretary Treasurer of the Road District. I feel it's really important to clear up some issues that were just cited. First of all, the Road District does have a meeting and meets all requirements of notice for meetings. And those are posted and sent out to every person who is a legitimate member of the road district. Now, the road district requires that you be a current resident, a registered voter, and several of the people that just spoke, well, actually, none of them met the requirements for the road district in order to be on the board of the road district and to vote for matters that were before the road district.
Prior to this year.
Prior to, well, that's in question. But anyhow, with that being said, when Bill and Donna moved to the area, we encouraged them to register as voters and participate and be active members in the road district. So to falsely accuse us of mishandling items for the road district, I think that's unfair. The other issue is funds. We have meetings every May 5th, first Tuesday of May, and the members that were on the board of the road district and members of the district had put before all of the members that funds be accumulated so that we could do the proper improvements and maintenance on the main roads to get them to a more usable state by regrading, regraveling, and hopefully asphalting that center Summer Creek Drive road. All of those things were discussed and voted upon. So the mishandling of funds, I'm sorry, but the Bank of Dan and Nancy have been paying for all of the road work that has happened. The road district has paid for nothing. The road district funds are all still intact. We get maybe $3,000 a year. And those are the funds that have been collected and we are building. And anytime they want a P&L, if they're a legitimate member of the road district, they're more than happy to get that to them. So on the road district, that's all I have to say.
I have a question. Can I ask
I'm
Nancy
Dan
a question?
Evangelisto.
Yeah. Oh, Karen's got a question.
Can you tell me how many members there are, legitimate members of the road district?
When we started the road district, there was, there was myself, Daniel, Tim Milborn, and Carsey Greco, Dwayne and Carsey Greco.
And now?
Now there is,
Should be, well, they've changed the rules this year. It used to be you had to be a full-time resident, you had to be a registered voter. And of this year, it's my understanding that if you're a property owner, doesn't matter if you're a full-time resident or a registered voter in the county, you have a vote, and you can hold a position on the board. So that.
You can?
So that has changed. That's my understanding of the letter that we received.
they're just in the process of changing it, so there's some gray area. They aren't even 100% sure. They're having to get clarification on who's a valid voter in the district.
You're saying it's changing by the road district, or is this state law?
State.
State law is changing.
State, yeah.
So right now, as it sits right now, who is a member of the road district, a voting member?
Be six different families, as far as I know.
That's not, is that with the changes in the law?
Yes.
Okay, without the changes in the law, who
I would
is a
have to
member?
get a list from Julie Pearson, because I'm not sure if they're still upholding if they're registered voters or not. So that's kind of an odd thing. Every year we get a new list as to who is actually a member, an authorized person.
Okay, thank you.
Mr. Chairman,
Ron,
can I make a motion? I'm going to make a motion to continue this till May 25th, which would be not next meeting, but the meeting after that, which will be the first meeting we have after they have a road district meeting on the 12th of May, which is the second Tuesday. And knowing Mr. Hague, he will make sure that that happens and get proper notice out. And I would suggest that anybody that lives out there and is interested better make sure that they do whatever it takes to become a member of that road district and a voting member, if possible, and that's my motion.
Second.
we have a motion and second.
And
PJ,
can I
you-
just clarify? Oh, it's going to be the May 26th meeting?
Yes, Monday is Memorial Day, the 26th would be the next planning commission meeting.
Sorry.
the one you-
Yes.
We have a motion and second. Further discussion.
I would rather have it at the next meeting, but that's on the 11th, and their meeting is not until the 12th, so.
Further discussion. Had somebody in the audience wish? Please come to this podium and let him take the podium and let Mr. Briggs speak.
This is Gary Briggs again, and it's easy to just Google road district, state of South Dakota. You'll see that the law, South Dakota changed the law several years ago. This didn't just happen. It is true that years ago, you had to be a resident, voting resident, to vote in a road district. But several years ago, the state of South Dakota changed the law. Now, if you are a property owner in that road district, you have a vote. But there's not been a meeting since May 17th of 2012. In that meeting, I wasn't there because I was never told about it, but it was brought up at that meeting in the minutes. How come people aren't invited? Oh, they said they would correct that. It never happened.
We do have a motion second on the floor. Any further discussion should be directed at the motion, whether to approve or deny continuance.
One thing, I don't know if this is even procedurally necessarily possible, but it's my client's recollection is the first Tuesday of every month. But regardless, I don't see any issue with having it a week early. I mean, it's not necessarily, I think you have it within a reasonable time period before or no later than the second Tuesday. So it could be certainly properly noticed. There's plenty of time to properly notice a meeting of the road district, just so it isn't set back another meeting time for the commission, if that would be possible. The second thing is that because of the hopefully spring rains that may come or not, but if heavy rain, it's my client's concern also about stormwater drainage. And if it would be possible to have a provisional approval or whatever particular mechanism it may be called, but at least a partial approval to go ahead and install the culvert to handle any potential, if there was a heavy rain, to diminish any possibility of additional damage, to have that approved today. And then I presume with the understanding that if this is not approved in the future, at a future meeting, my clients are out the money and resources that it took to do it, but that is a concern to them.
Mr. Chairman, so are you suggesting having the meeting earlier than the second meeting in May, so you can get back in front of this board earlier?
Yes, yes, Commissioner, it's my client's recollection that it's the first Tuesday. However, if it's not, there's no reason that it couldn't be on the first Tuesday if properly noticed. I think it's more of a no later than the second Tuesday.
I guess I would have no problem in amending my motion. The sooner the better, I guess, as far as I'm concerned.
As long as it's
I don't care.
legally allowed, I guess, as far as if it's.
Sure.
Unless it's set
We'll double check that.
Kim thinks it's legal to do that and everybody gets notice of it, I guess. Why not? And as far as the culvert, I haven't heard too many objections to putting it in. I've heard objections to who's going to pay for it. So I guess I wouldn't have an objection to putting it in either, but.
And I'm glad you brought that up again, because as my client stated, there have been no funds used out of road district taxes that have been put in the road district accounts to pay for anything that's been done so far, including things like snow removal and so forth that my clients have all done at their own expense. And there are, not to get off on this tangent, I apologize, but there are extenuating circumstances. If you recall the covenants that were attempted to be implemented, it angered a lot of folks. Because of that, we ultimately removed the covenants, did a filing and removed the covenants from their specific properties to appease that. Since then, there have been at from both county and state levels on every possible turn, they've been what amounts to be a vexatious effort to harass my clients, including personal harassment of leaving antelope carcasses on their driveway area to one carcass, I don't want to exaggerate.
I think you're getting off the motion. The motion is either to continue.
Yes, I apologize. I want antelope carcasses in the motion. No, just kidding.
Kinsley.
Okay, I just pulled up the statute for road districts, and I just wanted to clarify that it looks like the annual election of officers shall be held on the first Tuesday in May. So-
Shall be.
Yeah, shall be the first Tuesday in May.
So
just
with the
that's
second's
clarification.
approval, I would change my motion just to continue this till the next meeting, which would be after the first Tuesday in May. And
I
I
would-
think it's the
May 11th.
May 11th, yeah.
I would agree.
The motioner and second, and both have approved changing it from continuing to May 26th to May 11th. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Aye. Opposed, same sign. Motion is to continue is approved. Item 10.
Familiar property. Item 10 is construction permit CP 1509 to grade and level an area of a hillside in order to construct a building. It consists of lots 10, 11, 12, 13, and 15 to stockpile material at other locations. Lot 27 of the property into level and grade an area for overflow parking lot. This is the same general area. You can see the areas in orange here. This is where they want to grade and level an area for overflow parking. This is the area of the hillside where they're grading and leveling, and then they're have a stockpile location here. These all are existing. This was all in front of you also in November, where you wanted them to separate out the work being done by the private property owner and by the road district. It does appear that they have excavated over 10,000 square feet without a permit. Part of this area, though, is where they're doing their building, and our ordinance does allow them to do some work, excavating and grading for the purposes of their building permit. So this is what the property looks like now, that larger area here. They do have some stabilization. They don't have this area stabilized currently. So staff is also recommending to continue this to the May 11th meeting because of the violation on the property with the construction within the section line right-of-way. Typically, when there's a violation on the property, we don't recommend approval of additional work unless the planning commission wishes to approve the work. There are 12 conditions that staff is recommending.
Mr. Chair,
Lori.
can I ask a question? Is there an approved SWIP for this work?
No.
Okay.
And I have spoken to the state regarding this. The overall area of construction is over an acre, and I've been going back and forth with William McCoulier to determine whether this is that smaller subdivision within a larger, area. So we're trying to determine if this falls into that because it's one property essentially, but two different work plans.
Because in my mind, this is no different than the situation we just had a few weeks ago with the guy in the heliport.
Correct.
People are seeing stuff moving around, it's creating a problem. I guess I would like to see that addressed, that should be addressed. That's my biggest concern.
Other questions for Brittany? Mr. Evangelista, you care to comment?
I do. Again, my name is Dan Evangelisto. The staff is recommending continuance on this construction project, or the amendment to the construction project's already been approved. This is the amendment to the construction permit.
Sorry, can I clarify that?
Mhm.
Actually, you guys denied it without prejudice in November.
Okay. That's unaware to me. I've got a paper in my binder that says it was approved. But the recommendation for continuance is because of the Summer Creek Drive road issue and the section line right away. I don't know why the road district issue is getting pulled back into this private construction permit. As far as surface water runoff on this property, the location where the culverts are on the opposite side of Summer Creek Drive. That water runoff has always been there. It's not generated by this construction site. This site here used to slope all the way over to Summer Creek Drive. So if anything, flattening it out has reduced the amount of surface water runoff. The parking lot that is currently there was approved by the county commissioners 3 or 4 years ago, so that's always been there. The overflow parking lot that is mentioned was approved by the county commissioners. All I'm asking for was to gravel it. Brittany's the one that said that we should put the verbiage of grading in there, just to be safe, and if that's gonna throw red flags and hold things up, we could remove that. Would just need to put some gravel down. So I guess I don't understand why we have to connect the road district issue, which I know there is one, and we've said in the prior motion that that's gonna be addressed, why that has to be attached to this separate construction permit.
Questions for Dan? Has the SWIP plan been developed and submitted to the state?
It's my understanding with Brittany that I was not over that. Something has changed, that was the first I've heard of it.
In both the construction permits, anytime it goes over an acre, what I'm trying to determine, and this was discussed at the November meeting, was talking with the state to ask them, because the way that you look at it, there's two separate work plans, but it's one property. So in my mind, if the state determines that the overall, if it's, the property is an acre of disturbance, then they would require that. And I've talked to William about it, so that's kind of where we're at, determining that. Typically, it's the applicant's responsibility to work with the state, because it's the state rules to determine whether that acre has been disturbed. If you look at the overall between the two, that would be over an acre. It's just whether they consider it one lot, or, because it's two separate plans within one.
The part of the last item number 9, part of that construction permit was just improving the roads, and according to Brittany's statement then, I don't even need a construction permit for that, so we need to back that part off of that construction permit. Possibly that would put us under that 1 acre requirement, I'm sure.
Mr. Chair?
Larry?
Yeah, I guess I'm a little confused too, because, our original recommendation was to separate these things, and it seems to me like these
Pull them
conditions
back together.
combine them. So, Brittany, can you clarify that?
When our office looks at an overall property, there's a violation on the overall property, so we don't approve any, like, continuing, just like with a variance or anything, we can't issue a building permit until the variance is granted, even if it's something that, correct, is on the property. So that's how we look at these things. If there's a current violation on the overall property, we as staff can't approve any additional permitting or work.
But yet, you don't recommend, you recommend continuation, but then you say, if we approve the construction permit, you recommend the following so many conditions, and it ties them back together again. And so I guess what you're saying is you have to tie them back together because there's violations? Is that what you're saying?
The violation is the property as a whole. So yes, essentially, as the property as a whole, when we look at the lot, the tax ID as a whole, it has a violation on it, whether it pertains to a separate work
Okay.
or this work, it's the overall property. And that's not our practice in our office to continue issuing permits when there's a violation on a property.
Because I think, that's pretty confusing to the applicant.
Right. But I mean, that's how we. Right. And I understand that, and but that's why I did say, but if you guys wanted to overlook that, and that he is in good faith going to go in front of the board and get his permit,
Then these are the conditions to correct that situation?
Correct.
Okay. All right, thank you for the explanation.
I guess one comment, Dan, that you made that I think without some detailed calculations, you can't just say because you're flattening it, you've decreased the runoff. I mean, it's more complicated than that. You may have decreased your time to peak, but you may have increased the volume. And may require, I mean, for staff, when they review it on, was mentioned earlier, I mean, you look at drainage to hold the historic values. And so by removing vegetation, even though you're flattening it, you may not be moving the water as fast, but you're putting more water in the drainage, potentially.
You're increasing the surface area.
Yeah.
But there again, the park in that and the building permit have already been approved for that site.
Well, anyway, correcting a statement you made.
Yes,
that
okay.
You can't assume just because you're knocking it flat, then you've decreased the runoff, so.
But it's been my experience in construction over the years that that's kind of the case.
Anyway, staff is recommending for continuance, although has provided 12 conditions if we do decide to move forward. Anyone want to venture a motion? I guess maybe I should, before we go to the motion, is there anyone wishing to speak on this matter? Mr. Briggs, start with you. Sorry.
Again, my name is Gary Briggs, and can you pull up the plot map again, please? You're talking about, yeah, thank you, yep. You're talking about drainage issues and everything. We talked before about that approach that they wanted to build onto Highway 385, which was originally set up as an emergency exit in case of fire. What he's done is he's taken, now, and this is what I don't understand, is it's kind of like he's here asking for a permit, but he's already done this. So when I put in my septic system, I went and got a permit first. When I built my house, I went and got a permit first. This seems to be odd that he's done all this stuff, and now we're here wondering, can he get a permit? So in that escape path that goes to 385, he has already taken the spoils from this hillside that he's flattening, and he has a row of spoils approximately 8 foot high on that road, 8 foot high, 186 foot long. He cut the fence wire between the property and the highway, and he has gone into the ditch along 385, approximately 40 feet into that ditch with spoils, 10 foot high, dumped down that road and built back up. So that's one of the areas that he's used to try to hide his spoils. The other area was the section line and the national forest. The other place he's dumping his spoils is lot 27. Now, the problem with that is now he's got this anywhere from 4 foot to 12 foot high mound of spoils. My septic drain field, now you don't see the topography here. This is a slope going downhill. My septic drain field is right there. It's basically a dam right below my septic drain field. So we're talking about drainage and how, if we get a heavy rain, how this is going to affect everything. You know, not only is there was no water, there was no erosion fencing put up around any of this. There's no wind protection put up. There's nothing, it wasn't watered to keep the dust down, nothing. I mean, he's created a mess in our neighborhood. And he's damaged, like I said, I talked before, he's damaged the road. He's operating as, it's really a nuisance to everyone living in this area. Him running up and down the roads with equipment all the time. He doesn't have the proper equipment to do it, so he does a little at a time. It's just a nuisance to everybody, a danger to my children and grandchildren when they come out to visit. It's an eyesore. There's also been numerous complaints to the sheriff's department. The police have been called out many times. Somebody's moving property stakes. We don't know who, but there have been many issues with property lines. The police have been called. I'm sure you can access the sheriff's records to find out how many times they've been called out by both parties. So there's just been so many problems with this bed and breakfast, with this fiasco that's going on. We would like that conditional use permit pulled. It's been a problem. It's hurting. I'm the only one that owned the property prior to them being there. Everyone else has left. You're not helping the value of the property by having this thing here. You're hurting the value of everybody's property around it. They're all getting out of there.
I would comment, I guess, pulling the conditional use permit is not part of the action today. And again, like on a previous, you sat through the previous agenda items, if you wish to file a formal complaint on the conditional use permit, we can post that, publicly notice it and have it at a formal meeting. But this isn't the forum today to look at removing the conditional use permit.
Then the main question is, why was he allowed to move all this dirt, pile it up all over our subdivision, and now we're talking about a permit? That's what we don't understand. Why wasn't this stopped before if he didn't have a permit?
I believe staff did stop it when it was brought to their attention. Is that correct, Brittany?
This has been going on since September of last year, and they are allowed to do up to 10,000 square feet of dirt work on their property, and he's also allowed to do dirt work associated with his building permit, which he does have an approved building permit. Now, there is question about what's being built, but he does have an approved building permit, so he's allowed to do the dirt work that's associated with that, and he can do up to 10,000 square feet. So he did come in September, he was before you, or maybe September, but this has been going on since September of last year, so it's been continued. You guys, denied it without prejudice in November and had them come back and separate out the work, and so here we are, essentially.
I guess the question that keeps getting brought up, and again, we tried to separate the road work from what's happening on on private property, and, but it does seem like it gets mingled.
It is, like I said, there's a building permit, there's private work, and there's road district work, so separating that all out and determining what's what, and, that's where it gets difficult.
My question, I guess, Brittany, or clarification, I guess, is on the other roads that were referenced that aren't really developed roads yet, are those dedicated to public right-of-way, or, are those, they're within his, if they aren't dedicated, they may be shown on his, but he's got all the surrounding property on some of those roads.
Correct, and the only one that is dedicated is that 50-foot wide Summer Creek Drive, according to the plat. That's the only one that's public, the rest of them are private, according to the note on the plat.
Even if that road is there and he's putting dirt on there, it's basically on private property, is that what you're saying?
It's within the road district, because he formed a road district. If those are within that road district boundary, then yes. Even Summer Creek Drive, even though it's public right-of-way, it's within the road district's jurisdiction, if that's the way that the road district is set up. I've talked to our highway department at length about, this, and once Summer Creek Drive was taken under the road district, then that's kind of their responsibility at that point.
Mr. Chair, can I ask another question? And then just to clarify things, was there ever a stop work order issued?
Like an official, handover? No.
Because people keep talking about him violating a stop work order.
Right, and I do know that when he was at the counter at the office, the planning director did tell him that no work was to be done whatsoever.
No additional work
Correct.
that was outside of the construction permit that had already been approved?
There hasn't been a construction permit approved.
Okay.
The one that was approved, 1407, was amended and brought to you guys. So you guys denied it without prejudice for them to separate it, because the original construction permit did not encompass
the road work.
All of this, yes.
Okay. And then other than it appears that they do not have a valid construction permit in place, correct?
Correct.
Other than that, there are the issues associated with the stormwater runoff, right? The drainage issues that we've
There
already
are
talked
concerns from our drainage engineer, yes.
Okay.
Well, yeah, Karen.
You said there was some question about the building permit. They can do grading as a function of the building permit?
Yes.
So what's the question with the building permit?
And that's like a separate issue. And Mr. Evangelisto has asked me if he's, getting the site ready to pour concrete for his building permit. Under our zoning ordinance and the building permit, he can do that. We don't that's a separate issue from the other disturbances. He still has to follow best management practices and good housekeeping and those things, regardless of, our stormwater manual says any construction activity, no matter whether it falls under the NOI, the SWIP, or anything like that, he still has to follow those best management practices and good housekeeping requirements.
It seems like part of the concern is when the spoils are leaving the site. I mean, I can understand dirt work on that site, but once they're leaving the site, I guess you,
And that's part of the confusion still, is some of those spoil piles from the private work is being.
From the building permit.
From the building permit and this construction permit is still going to the road district stuff. So there's still that, and I don't think that there's any way to completely
cleanly separate.
separate that. So,
It almost sounds like, I guess, what I'm kind of hearing is just like Ron had suggested for the previous action. I mean, since it's directly affecting the road district by what's being done with the spoils, it's probably appropriate to wait till after the road district meeting.
I would agree.
Lori, looks like you got a comment.
Because it sounds like there's a question about, from the residents in the area, that there are things that look like they've been being done, saying we have this approved building permit, but it looks like it's outside of the scope of that permit. Would that be a fair characterization of the work that's being done?
with the major like grading and the moving of the material.
Because there's a building permit.
Right.
But some of the people here that have spoken today are questioning, the question came up, how did this work get done without approved permit? Because there's not an approved construction permit.
Correct. There's there's not an approved construction permit, but there is an
A
approved
building
building
permit.
permit.
So it seems like some of this work has been done under the building permit, but it may or may not be outside of the scope of that permit.
Correct.
Would that maybe?
That would be my assumption.
Okay, that maybe clears things up a little. Okay.
Is there anyone else wishing to speak? Dan, Nancy, Kent, any further comment?
Probably one comment in regards to Mr. Briggs on this stockpile. It's a temporary. It's not going to stay there, obviously. Couldn't sell that lot with a stockpile of material on it, so that's a temporary thing. And as far as his concerns with surface water impacting his drain field, Brittany and I have had conversations about that. I don't think it's going to have an issue, and I told Brittany if there is an issue with that, I can take out the temporary approach leading to that stockpile or put a culvert in if she deemed fit. And her and I agreed that we were going to monitor it, and if it needed to be culvert put in or the temporary approach taken out for drainage down the side of Summer Creek Drive, I'd be willing to do that. And we've talked about that last year, so.
Does staff agree that the drainage field isn't being impacted at this point in time?
From what I could see, I didn't see anything, but this has been a pretty dry year, so there hasn't been a whole lot of moisture, so I'm not really sure if that's a fair, assumption. But that's why he and I had discussed that if there is an issue, that a culvert or something would get put in to at least route the drainage so it doesn't back up and impact that drain field.
Mr. Chair.
Karen.
May I ask a question? What are you planning to do with that, with the spoils that are in that pile permanently?
I'm gonna give it away, or I'm gonna basically giving it away. There's already some people that have shown interest, 3 different parties that live within a few miles that want some for different projects they're doing on their property in their neighborhood, so.
Do you have any idea when that will happen?
Within the next year, I would say.
Can I make one more comment? It seems to me like this whole issue, the issues with the stormwater need to be worked out with you and the state, the DENR, correct? So that, the county's satisfied that you're meeting their and the state's stormwater requirements. The issues with the road construction, I think, need to be worked out with the road district.
Absolutely, and this is the first that I've heard about needing to contact the state for anything. I was under the impression when I made all these applications that I was under the limits to have to contact the state.
Yeah, and I mean, construction can easily get outside of those limits, and then there's a question about, that happens all the time in construction. So, I mean, you know, you're not the only person that's ever run into that issue. But the whole road district things, all that construction stuff needs to be decided by the road district.
And granted, I can view their concerns. The construction site I have going around right now with any construction site, they're ugly. When we built the bed and breakfast, when you cut the site, and you're up in the hills, you have topography issues, you have to cut flat shelves. It looks awful. But if you come out, any of you want to come out and look at the bed and breakfast landscaping now, I encourage it. It looks great, so. Granted, now, like any other construction site, it doesn't look good, but part of the construction permit is our guarantee that everything's going to be put back and vegetated and green, so.
Staff's recommendation is to continue, but they did offer recommended conditions if we decide to move ahead. I would entertain a motion either way. Barb?
I'll make a motion to continue construction permit CP 1509 until the, what is it, the
May
meeting on the
11th.
12th?
11th. May 11th. I'll second that.
We have a motion and second to continue to May 11th. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carried. Item, before we go to item 11, why don't we take a 5-minute recess? If you, I don't know if there's any street parking that you've done with the issues getting into the ramp, maybe end up picking a parking spot, and if it's more than 2 hours, you will get ticketed, so now's your opportunity to, during this 5-minute recess, to move your car. Audience, I appreciate your patience. This is one of our longer meetings. Unfortunately, we get tacked on the end of the agenda, so.
All right, item number 11 is the review of conditional use permit 9611 for Donald and Norma Lindy to review a double-wide mobile home as a caretaker's residence in a low-density residential district. The existing land use is residential. In 1996, the applicants initially requested the conditional use permit for the double-wide mobile home to be placed on their property as a caretaker's residence. That was approved, and this conditional use permit has been reviewed several times since then and subsequently been approved for extension each time. Excuse me. On December 17th of 2014, the applicant submitted a layout plat request to create 2 additional lots on their property. Essentially, they are looking to create Lot 1 here and Lot 2 here of the property, so here up in the, the northeastern corner. And that was approved by Planning Commission on March 23rd of this year and subsequently approved by the Board of Commissioners on April 7th. During the review for that layout plat, staff did perform a site visit and there were a few issues that came up. Currently, the property consists of 3 single-family residences, a barn structure, and several outbuildings and small sheds. This right here is the caretaker's residence that is currently being used. The applicant has stated that the caretaker's residence is inhabited by one of his daughters and is used to provide care for himself and his wife, so it is still a necessity for them. However, during this site visit and throughout the plat process, we have identified that there is a mobile home on the property up in the northeastern corner that was placed on the property without an approved building permit, and there is no conditional use permit to allow that 3rd residence on the property. Originally, that mobile home was a 1970, I believe a 1970, and then also a 1973 mobile home, so it was grandfathered at that time. However, since they have moved a new mobile home onto the property, the applicant indicated that that was sometime between 1999 and 2000, which does end the grandfathering status. So the applicant, if they were to continue with the platting process, filing a final plat with the Register of Deeds would bring that mobile home into compliance since it would be on its own separate property. However, it would still be required to obtain a building permit and pay any applicable fees and penalties. Another issue that was identified was the setbacks for 2 of the existing residences were questioned during the interdepartmental review process for the plat. 3 conditions of the layout plat do address the violations on the property of the extra house and the setbacks. Also, access to the property is currently off of Boulder Hill Road via an existing approach. However, that approach has not been officially approved by the Forest Service. It is across Forest Service property. The applicant has applied for a Federal Land Policy and Management Act private road easement with the Forest Service. However, Rodney Brown has stated that the review of this request is tentatively scheduled to be completed in 2016 or later. I did reach out to Rodney Brown from the Forest Service, asking him if he would give formal approval or some sort of approval for the applicant to continue using the existing access across Forest Service land until their road easement request has been approved, contingent that they made no changes to the existing structures or basically did anything on the property. And at the time of the staff report, I had not heard back from Rodney on confirming that that would be okay. However, the applicant is surrounded by Forest Service on all sides. So staff doesn't have a recommendation at this point. I am requesting guidance from the Planning Commission on how to proceed with conditional use permit 9611 due to the fact that the caretaker's residence is still needed. However, there are violations present on the property and official access may not be approved until 2016 or later.
Questions for Cassie? Jim?
Cassie, what happens if the Forest Service doesn't provide approval? What will the Forest Service do? Will they block the road? Will they sue them in court? What will they do?
That I'm not sure of. I would have to ask Rodney. Rodney essentially in previous comments and things like that I've had in contact with him has said that he doesn't foresee the Forest Service taking away their access. It's just a matter of getting the official approval from them.
Okay, so for all practical purposes, there is a provisionary approval provided until a formal approval comes down the line?
Yes, and they have been using this access. The original house on the property was built in, I believe, 1965, and they have been using this same access since then, which is another reason why Rodney had initially said he doesn't foresee them not granting them access, but it's just they don't have an official easement from the Forest Service at this point, and I couldn't get clarification from Rodney on whether he would give me formal approval that it probably wouldn't be
And this approval
pulled.
wouldn't come until 2016?
Yes, the Forest Service is currently predicting
Busy,
that
or what?
easements, yes. They're predicting that easements will take for anywhere from 18 to 24 months for formal approval at this point.
Well, I more or less answered the question I had in a similar, is they have not taken any actions to cut off that access?
No, there hasn't been any actions. To my knowledge, the Forest Service has not reached out to the applicant or anything along those lines stating that access would be removed. It's just that we don't have official approval to be using that as an
Well, and
easement.
I'm sure Forest Service, until it goes through the process, he isn't going to give you a provisional answer.
Yes.
One other thing, I'm just curious. The caretaker residence was 1996.
Mhm.
Who was the caretaker taking care of?
The
That was
applicants.
20 years ago.
At that time, I believe she was still taking care of the applicants.
Oh, okay.
To my understanding, that's always been the scenario.
And the caretaker the caretaker residence needs to be maintained, is that right?
Yes.
There's a need?
Yes, there is still a need for it.
Mr. Chairman, this is going to sound cruel, but do we ever get any proof of that? Or is that just yep, got a caretaker living here?
The only requirement we have is that to initially get it, that they provide a letter from a doctor saying that care is needed by who, for who. And then when it comes up for review, we check to see if care is still needed, and they say yes or no.
Okay, well, that's better than nothing, I guess.
Who says yes or no?
Yeah.
The applicant.
The applicants.
Oh, so
Another
we don't-
doctor's note is not required.
We don't check with the doctor again. The applicant may be,
There's other
wholly
questions that,
restored
yes.
in health or whatever, but
Yes, or is the applicant
Okay, so
deceased?
all right.
Is the
I
person
see.
deceased or stuff, yeah.
Seems like a bad
I trust
practice. but-
people sometime, I guess.
And the applicant is here if you guys do have any questions for him. Mr. Lindy is here.
Is there any indication of timeline? Because like some of these violations go away once the plating occurs. But I mean, you could sit on a layout preliminary plat forever and never formally file that. So right now, we don't know when that action will be done to basically clear the violations.
Correct.
By plating action.
Correct, yep. Ultimately, it is up to the applicant how quickly the final plat gets filed, how quickly they proceed with the platting process.
Other questions for Cassie? Is the applicant wishing to speak?
I'm Donald Lynn, and my daughter is the one that is the caretaker, and she does all of our medical. She does the majority of the cooking and cleaning and everything. And I had went to the Forest Service, like she said, and he told me, basically, he told me it could be 2 to 6 years because they have to check to see if there's a monarch butterfly. That's the words he told me. But earlier, they also told me that they wouldn't block me from access. And he said usually they would send a letter and saying that I had applied for it and that you guys could go ahead. I don't understand everything. Setbacks, I don't understand what you're saying that I'm doing wrong, but, and yes, I plan to continue the 2 lot things. I tried to get a hold of, can't remember her name, Friday, and she was busy, and I tried again, that was dinner time, so I didn't get a hold of it, but I plan on it. I don't know what always, I know there's several things that you had that I have to do.
Questions for Mr. Lind? I guess, do you have a time frame when you're looking at doing a plating action to create the lots?
Well, whatever I have to do to comply. I mean, I'm hoping soon, but
And Cassie, just to confirm, you were saying the properties are entirely surrounded by Forest Service? Is that correct? Okay.
Yes, in terms of access, being able to get access off of Boulder Hill Road, all of that is Forest Service land.
Okay, well, I guess what I was kind of leading at is,
Right.
if the surrounding property is all Forest Service, there isn't going to be other private property on any of the borders surrounding the lot?
No, the only other private property is to the south, but they wouldn't be able to take access off of Boulder Hill Road from there. There's pretty steep ditches and things like that.
Well, I'm kind of talking around the point I'm trying to get to. I guess the point I'm getting at is where they're located, no one could build a house, so, or, yes, we have setbacks, I guess, is that critical in this point?
Correct. It's surrounded by Forest Service to the point of no one would be building a residence there.
Okay. That's what I was kind of fishing for, so.
It appears that they can't file a final plat until they get that approval from the Forest Service, can they?
We should just continue this till 2016. This is what you're saying.
Well, I'm going to have one more condition that you just well keep in mind. That is, when you said the applicant would still be required to obtain a building permit and pay all applicable fees and penalties, and I would insist that there's also an agreement by the applicant that he will not contest those fees or appeal it to the county commission. Because we have the habit of being a game show and giving away money.
Well, I didn't realize that, I thought when you replaced, I did not realize that you had to have it.
I understand.
Questions for staff or the applicant? Staff didn't provide a recommendation, so it's open for any motion someone wishes to make.
Well, what motion do we have to have this continue and have him do something so we can get it straightened out?
In terms of resolving the building permits, or in terms of resolving the access, or?
Well, the building permits, and what he'll have to do is try to rezone it, won't he? Or, I mean, split it up.
Yeah, if he were to finish with the plating process, which could take time, but if he were to finish with the plating process, that would create the 2 extra lots, which would bring the 1 property into compliance. It would still need a building permit, but it would bring it into compliance on its own property. But I don't know how long that will be.
Well, but he's in violation now, so can't we tell him how long it'll be? I mean,
What are you thinking? A couple of months?
well, I don't really necessarily care, but, you know, whenever he gets around to doing it, well, if you're in violation, that's not the right answer, is it?
Are you looking to, time for him to start the process or have the process finished?
I don't care.
Okay.
3 months, 6 months?
I'd say 3 is probably a better
It'll
option.
still be before the
Yeah.
Forest Service acts.
It's a lot of work.
Either
And I
city or
suppose you're
just-
gonna have trouble with the access then.
That's the main issue.
But how does that lot on the, with the existing residence, how does that take, how do you get in there?
Get a closer look.
There's, excuse me, there, right through, through here, there's actually a road. And on his, layout plat, he has dedicated this easement through the property, that does go all the way back here to this
So that's the
residence.
access.
Yes.
Within the property, but
Yes.
not outside the property.
But what's the access to the existing residence? That has legitimate access to the Forest Service?
It's coming through the Forest Service
Yeah,
without,
Since 1965.
but not being contested by Forest Service
Right.
or approved.
Yes, exactly.
Yes. Right. That's the issue.
So theoretically, if they're not gonna contest that, they're not gonna contest his easement to the other property.
Well, it would be on his land and through the plating, so they wouldn't really have any.
Well, but that, you know, it'll be an additional burden on that easement theoretically, but, okay, whatever.
Are you saying that in order to have the preliminary plat, he needs some approval from the Forest Service for this?
Primarily, this body usually has concerns with plating if access is not
But we can't
verified.
say, we approve this preliminary plat even though the man has an illegal approach.
In the future?
Yeah.
It's up to you, but right now, it's just a CUP
Shrug and
review.
say, well, if the Forest Service, which is a separate entity, shuts this down, we're sorry. But in the meantime, our portion, we're willing to approve this.
Well, to sell a property, though, you have to have legal access.
Yeah.
And right now, that doesn't exist. So, I mean, even though it's historic.
Yeah.
Hence the dilemma.
Could continue this for a couple years? Is that what we're thinking of doing?
That was my first
Well,
suggestion.
that's essentially, that's what I was kind of thinking, is like you basically approve the conditional use permit with the contingent that you plat it within 2 years.
You probably need to have a caveat in there, though, to get the building permits and everything. The delinquent building permit needs to be.
Oh,
Yeah.
yeah.
You'd want to take care of that now, or your fines are going to continue to
Right.
to accumulate.
Right.
You're just going to end up paying 2 more years of fines, right? I mean,
It's
is
the same.
Oh, it's
It's
just
the
a
same
flat, it's a flat
regardless.
number, okay, okay.
Good thought, though. But we could definitely write conditions that state, you know, essentially what you want and what Ron had mentioned, if that's something you guys want to do. We could draft them up real quick.
That's what I would suggest, is I guess a motion to approve the conditional use permit with a contingency that plating action take place within the next amount of time to be, you know, or, you know, with the conditional, and at that point, if they're in violation, when the deadline's reached, then it's automatic, could be revoked. Right?
Yes.
And then you have a review in 2 years, or whatever time period we want to set.
There's a lot of options, whatever, you know.
And they
You
have
guys want to do a
access.
lot of precedent either way.
I just feel like there's things that are beyond his control. You can't control the Forest Service.
Correct.
And to penalize him by non-action doesn't seem fair.
Correct. We got
We could add a condition that essentially says something along the lines of that the final plat to create lots 1 and 2 of Lindy subdivision be submitted to the Register of Deeds no later than 2 years following the approval of extension.
When I'm saying 2 years, I'm hoping by that time we at least have Forest Service action to officially grant that road.
Right.
I don't know if there's any pressure the county can put on the Forest Service to act, given the, probably not.
It could read, or until the Forest Service renders a decision.
Well, what's wrong with the 2 years? What's wrong
Yeah.
with the 2 years? And if, we can always extend it if we have if they haven't done anything.
I'm sorry, I didn't hear that.
I said, we could always extend it if I mean, if it came to that. and the
Yeah, I think
Forest
it'd be better
Service
to
had
give
made
a definite timeline, and then just, if it's a Forest Service that's holding things up in 2 years from now, then we have to renew it, you know.
Right.
Extend it at that point in time.
I think that would,
Yeah, actually, I like that better.
And then also
Have a review contingent with that timeline, so.
and you may also want to add the condition about the building permits
Right.
being done by a certain time, and if you want, also Ron's recommendation.
what was the reference?
I see Cassie scribbling. I hope that
Scribbling,
means
yeah.
she's got all these conditions written down.
They don't ask for fee waiver. They don't ask
Not the what?
they don't ask that the fees be waived.
You have recommendations for,
And he's got to hire a surveyor.
is the ranch hand resident being used right now?
Yes.
Okay.
It is currently inhabited.
What day, this is.
Just for curiosity, do you have an estimate about the fees and penalties?
That's what PJ was just asking. I don't. I'm not sure. I would have to go back and look and see how big that mobile home is, and make sure also that there are a couple of sheds and things like that attached to that mobile home. I would have to make sure that those wouldn't need a permit as well.
Be in $500.
Yeah,
It's June. Yeah, it just gives you an
and he's got to hire a surveyor.
Yes,
Yeah.
that is one of the contingencies of his layout plat, is
Plating.
that a survey be submitted to show the setbacks.
Yep.
So that's already in the
They don't change.
layout plan.
Oh, no, there's some money involved in that.
Do we have a staff recommendation then for conditions, or are you?
Well,
kinda
checking on a time.
Okay.
Right now with the applicant, so. You want to go here? We're looking either May 26th or possibly June 8th for the building permits. Okay. Let's do the little cushion then and do, okay? Okay. I'm talking with the applicant as far as the building permit condition, recommending with the applicant's concurrence, June 8th. To have them in by then.
Okay.
Okay, so staff would be recommending then 9 conditions with the extension of this conditional use permit. There were 6 previously. So the conditions would be that building permits be obtained for any future structures exceeding 144 square feet or located on a permanent foundation, which includes the necessary site plans to be reviewed and approved by the planning director. Condition 2, that the mobile home has wood, hardboard, or simulated wood siding. Condition 3, that the mobile home has a wood or asphalt shingled roof. Condition 4, that the mobile home be removed at such time that the family member no longer needs assistance. Condition 5, that the property remains clear of unlicensed or inoperable vehicles and debris. Condition 6, that a building permit for the mobile home addressed as 23818 Boulder Hill Road be applied for no later than June 8th, 2015, and that the applicant pay all applicable fees and penalties. Condition 7, that the applicant sign a statement of understanding that fees will not be contested for the building permit applied for 23818 Boulder Hill Road. Condition 8, that the final plat to create lots 1 and 2 of Lindy subdivision be submitted to the Register of Deeds no later than 2 years following the approval of extension of conditional use permit 9611. And condition number 6, that this conditional use permit be reviewed in 2 years or on a complaint basis, or by recommendation of the Planning Commission or Board of Commissioners to ensure that all conditions are being met.
Mr. Chair, I will make that motion.
I'll second.
We have a motion and second. Any further discussion? Hearing none, all in favor signify by saying aye.
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 Opposed, same sign. Motion carried. Item 12.
Item 12 is a major planned unit development amendment request by Barbara and John Marjak. Staff did find out prior to this meeting just this morning that the notice of hearing letters for this planned unit development amendment were not properly provided. Is that correct, Jerry? Did I say that correctly?
Yeah, the applicant did do the outside the PUD within 500 feet, but the one inside the PUD needs to be done when you do a major amendment.
So we have notice letters that need to be sent, so staff is recommending to continue the review of the major planned unit development amendment PU 1501 to the April 27th Planning Commission meeting to give time for those letters to be sent.
Mr. Chairman, can I make a motion for that? I make a motion for what you just said.
We have a motion. We have a motion and second. Any further discussion?
Who seconded that? Ron?
Ron.
Okay.
All in favor signify by saying aye.
Aye.
Aye. Opposed, same sign. Motion carried. Covered 13 already. Item 14.
Item 14 is conditional use permit number 1505 for Troy Schmidt, Beach House LLC, Lisa McLaughlin as the agent, to allow for a vacation home rental in a low-density residential district. Excuse me. The applicant, Troy Schmidt, has applied to allow an existing 3-bedroom residence to be used as a vacation home rental. The existing conditions, this property is currently zoned low-density residential with a minimum 3-acre lot size. It is 1.6 acres. A variance was approved in 2000 to allow that 1.6 acre lot in a low-density residential zoning district. It is located east of Hill City along Old Hill City Road, approximately 1/2 mile south of Pink Cabin Road. Access to this property is off of a gravel driveway taken from Old Hill City Road, located in a dedicated access easement. The property currently consists of a single-family residence placed on the property in 2003, a detached garage built in 2000, an on-site wastewater system, a shed, and a well house. Staff did perform a site visit. They did verify that the house on the property is a 28 by 64 modular home that contains 3 bedrooms. Therefore, the maximum occupancy of the vacation home rental would be 6 people based on the sizing of the existing on-site wastewater treatment system that was approved by DENR in 2014. The applicant has also complied with all of the application submittal requirements for a vacation home rental as listed in section 319 of the zoning ordinance. And Lisa McLaughlin has been designated as the local contact for the vacation home rental. The only comment that was raised during the interdepartmental review process was the county fire coordinator did comment requesting that the phone numbers on the sheet that is provided with emergency contacts in the vacation home rental be updated with the correct number for the fire department and the sheriff's office. The applicant did provide proof for me this prior to the meeting that that has been changed on that. So no other significant issues were raised. The zoning ordinance does list 5 factors that the planning commission can consider in the review of a conditional use permit. Staff does not foresee using this as a vacation home rental causing any long-term negative effects or hindrance to enjoyment of properties in the immediate vicinity. We don't foresee that it would affect the normal orderly development or improvement of surrounding areas. They do have proper access roads, off-street parking, and by its very nature, a vacation home rental should not produce excess fumes, odors, dust, noise, anything like that. So staff does recommend approval of conditional use permit 1505 with 12 conditions.
Questions for Cassie? The only comment I have is the same one I had before. Here we have another LLC that changed the underlying. So I hope the Vacation Home Rental Committee takes that and part of their deliberations on how that should be handled going forward.
Can I ask a question?
Larry?
I noticed that the application actually has the person's name and not the corporation's name. Will this conditional use permit be held in the corporation's name or the individual's name? Both are listed on our cover sheet, but then only, I'm a little confused, I guess.
The conditional use permit would be held in the applicant's name.
Okay. So it's not going to be held in the LLC's name?
Correct. It would be held in the applicant's name.
Is that going to be confusing since all the stuff with the state has the LLC's name?
Yeah, the owner is still the LLC, and transfer, all that goes with the owner.
Okay.
And the applicant is their own name, so we look at the owner. Right now, the way the ordinance is, it's the owner.
Okay.
Any questions for staff? Staff's recommendation is for approval with 12 conditions. Entertain a motion to that effect?
I'll make a motion to approve conditional use permit 1505 with 12 conditions.
Second.
Motion and second. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Aye. Opposed, same sign. Motion carried. Item 15, rezone.
Item 15 is rezone 1412 and comprehensive plan amendment 1409 to rezone 3.5 acres from low-density residential to suburban residential and to amend the Pennington County Comprehensive Plan for future land use map from low-density suburban residential. This was applied for by Gordon and Carmen Abernathy with Agent Fisk Land Surveying for 3.5 acres. Essentially, this has been ongoing for a few months. On April 7th, the Pennington County Board of Commissioners approved lot size variance 1506 to allow a 1.3 acre lot and a 2.07 acre lot in low-density residential, essentially making the rezone and comp plan applications unneeded. Per the applicant's request, they wrote, in light of the approval of the lot size variance and on behalf of the owners, Gordon and Carmen Abernathy, we request that the applications for rezoning and CPA be withdrawn. Staff recommends approval of rezone 1412 and comprehensive plan amendment 1409 be withdrawn per the applicant's request.
Any questions of staff?
Mr. Chair, I make that motion.
Second. Motion and second for approval per staff's recommendation to withdraw the application for the rezone and the comp plan amendment. Any further discussion? Hearing none, all in favor signify by saying aye. Aye. Opposed, same sign. Motion carried. Item 16.
Good morning, Colin Hensley, County Planning. Item 16 is rezone 1504 and comprehensive plan amendment 1504 to rezone a .69 acre lot from Highway Service District to General Commercial District and amend the Pennington County comprehensive plan to amend the future land use from Highway Service District to General Commercial District in accordance with Section 508 of the Pennington County zoning ordinance. The applicant is Victor Furman. This is just east of Hill City on Highway 385. The existing land use is a retail business. The applicant currently operates a motorcycle repair shop on the property. Per Section 210, it has indicated he would like to begin selling motorcycles on the same location. This is not allowed in Highway Service District, but would be allowed in General Commercial District in accordance with Section 209, Bravo 23. Subject property has an existing 4,500 square foot building constructed in 1996. The property, again, is directly south of Highway 385 and takes access from the northwest. The entire property lies within the 100-year floodplain of Spring Creek. Surrounding area is primarily zoned Highway Service District and general agricultural lots ranging from .81 to 98 acres. Rezone was, and comp plan was routed through the interdepartmental review process. Only real issue was brought up by Water Protection Coordinator that it is floodplain on the entire property. Any work be done with the boundaries of the floodplain development permit is required. And then best management practices to continue to follow state and federal law for hazmat because it is a motorcycle repair shop, and then they will be selling, the intent is to sell motorcycles on the property.
Mr. Chair, it is really strange to me that you can repair motorcycles, but you can't sell them on a highway service. It makes no sense to me.
Correct.
The other thing that doesn't make, there's no general commercial in this area, so we're sort of carving something out that we probably shouldn't be, but I think I'd be in favor of it.
Okay.
Just a general principle.
As you noted, sir, the future land use is Highway Service District. There was no other issues brought up on the interdepartmental review. Staff recommends approval of rezone 1504 and comprehensive plan 1504 of the amendment. Pending any questions to staff?
I assume you didn't get any response letters commenting on the change to general commercial by any of the surrounding properties that were
No, sir.
notified. Okay.
That's my motion
I'll second.
to approve it.
Motion and second. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carried. Item 17.
Was that too easy for him? Did you want us to give him a little more grief? That was.
A little bit more would have been good. He needs the training. He actually did very well on that one. Let's see, here we go. Okay. Item 17 is rezone request 1502 and comprehensive plan amendment 1502 to rezone 151.36 acres from general agriculture district and light industrial district to general commercial, and to amend the Pennington County Comprehensive Plan future land use from limited agriculture to general agriculture district. Again, this is 151 acres, and the current zoning is general agriculture and light industrial. If you look up, I think you have it in your packets as well, but what's also on the screen is this is the subject property, and there's that tiny little bit of light gray, which is the light industrial. This does lie within the 3-mile plating jurisdiction of the city of Rapid City. The 120, let me get here. There we go. This is what, up what's on the screen is what the applicant is looking to have rezoned to general commercial. The area that's general agricultural at this moment is approximately 123 acres. And on that property, there's an existing single-family residence built in the year in 2000. If this rezone request was approved, that residence would require a conditional use permit in general commercial zoning. The applicant has stated that he would apply for and submit the conditional use permit. He actually filled it out the same day he did the rezone, but since there was no violation on the property at that time, I recommended that he not submit it because he's submitting an application for something that doesn't exist yet. But he has stated that he's willing to do it, and I do have a copy of that application. Of the area that is in light gray, which is the light industrial area, that's approximately 27.48 acres. And what is located on that property is a contractor's equipment area, storage yard for that equipment, and it's also a go-kart racetrack, which is done through a conditional use permit in the year 2000 with 10 conditions, and it was last reviewed and approved in 2005. The racetrack is a conditional use, as I said, in general commercial zoning districts, and it would be allowed if this rezone was approved through the continuation of a conditional use permit, even though it's in general agriculture at this time. Staff has not received any complaints regarding the racetrack and is unaware if it is still in operation, but having talked with the owner, it sounds like the owner and the applicant that the racetrack, the use of the racetrack, he would like to continue that in the future. So it's possible that the conditional use permit for the racetrack in its current zoning, if it's approved to the new zoning, may get carried over. The contractor's equipment yard would still would be required to be removed prior to the rezoning of the general commercial district, or the conditional use permit that it currently has be applied for with, or be reviewed and changed for when and if the rezone does occur. So he has possibilities to keep both of those. The rezone and the comprehensive plan amendment were routed through their interdepartmental review. Some items of concern came back primarily from the county highway department as far as access proposed on Highway 79 and off of Old Folsom Road. The county ordinance officer said that there were several violations on the property, but he said it was unclear how many, since the gate was locked and could not go onto the property to verify. A concern that he had is that there is a structure that has been demolished and piled up and needs to be removed and not burned. There was a call that was put into our office from a concerned citizen that there was some concern that the trash was on the property that may be burned. So that's why that was put in there as far as his comments. The City of Rapid City Community Planning commented specifically that the city's future land use identifies the appropriate use of the property as agriculture and light industrial, as shown in the attached map that was provided by Vicki Fisher, which is included in your packets. We did not receive any comments back, though they were questioned several times on this via email and phone calls from the South Dakota Department of Transportation, and that is an area of concern by staff and one of the reasons of what our recommendation is at the end of this report. Black Hills Electric Cooperative that owns the DC tie, has power in the area, says the rezone in itself will not affect BHEC facilities. The cooperative owns, operates, and maintains an electric distribution line in Section 32, approximately 650 feet east of Highway 79. The comprehensive plan for the area, if you look up on the board here, this is the current zoning for the property. Again, the light, what appears here, it looks like blue, but light green, and here it's general commercial and light industrial with general agriculture, light industrial, with right across the street is general commercial. The future land use in predominantly most of the area that the applicant is asking is general commercial. He is asking to add general commercial over to this area, which the future land use is which is limited agriculture. So it is in harmony with the future land use except for this area right here. And also that little bit of light industrial that he has down here, that's also part of his request to have rezoned.
Can you go back to the previous slide?
Sure.
Just for a second? So right now, across the road, that is general commercial, but you're saying that you envision that going to PUD?
Right now, the future land use has it as PUD.
idea why?
I do not know why. It would seem like a hard downturn. And when we revise it, that would be something to change.
Seems like a pretty good jump.
Huh?
Seems like a pretty good jump.
It's a big jump. With the unknown number of violations against Pennington County Ordinance 106 on the subject property, and the concern about the contractor's storage yard, and the lack of comments coming back from South Dakota Department of Transportation, staff is recommending that this rezone and comprehensive plan, excuse me, be continued until a written verification by the Pennington County Ordinance Officer that all violations per Ordinance 106 are cleared, that the contractor's equipment storage yard be removed or the conditional use permit at least reviewed to see if we can come into compliance with the future possible rezoning of the property, and that comments from South Dakota Department of Transportation have been received by the Planning Department. The applicant is in the room, if you like the question.
I have I guess, a question regarding the city's comment, and both a comment and a question, I guess, is, they're saying they envision this as agricultural and light industrial, which general commercial to me isn't as harshness, or if you will, as light industrial. So I mean, do you interpret that as being in conflict with if we rezone it to general commercial?
I do not know what their requirements are under the zoning districts if they have their future land use. Ours are different than theirs.
Yeah. Well, and I guess my comment would be, this gets back to needing an updated comp plan. I think that incorporates some of the changes that have occurred both on the county and the city side.
Yep. Yep.
We keep running into conflicts in these fringe areas where the city has plating jurisdiction, and then we just create a problem by zoning it different than their plating jurisdiction would allow. So.
You also bring up another point that I forgot. When the staff report was written, the only comments I had back from Rapid City Public Works are what's written. I noticed in the packet this morning, since we were out on Thursday and Friday for a training and weren't around when the final packets were put together, there are some running comments that are included in your packet from Public Works, which talk about essentially that the Public Works engineering will not be able to support proposed rezone without applicant demonstrating adequate infrastructure and can be provided to support proposed improvements in density. The property to be rezoned is located within the Rapid City's Tier 1 water and wastewater utility service zone and will be required to install dry water and sewer main per the city's water source protection plan when platting property for the development. And also further down, the city does not have any imminent plans to extend sewer and water services to the area. So that gives you some vision into what the city's planning on doing. Go ahead.
Just a question. I don't want to get too far astray, but what's the legal rationale for that the city has the platting responsibility and jurisdiction, and we have the rezoning responsibility? I mean, is this a function of state law, or is it a local adaptation?
The 3 mile limit's state law.
Yeah, that's state law, but it applies only to platting, not
Right.
to any other kind of usage control or like zoning or
As
anything.
far as I'm aware, that's correct.
It seems so odd, really. I mean, maybe there's a compelling reason why that distinction should be maintained. Seems like it ought to be changed, but.
And you're not bringing up a concern that I haven't heard in the last 2 years about the intergovernmental agreements and how to make it easier for
Well,
everybody.
I'm not saying we need to do what Sioux Falls does, but I mean, like, Sioux Falls does have a joint jurisdictional meeting where basically the city planning commission and the county planning commission meet on those issues just like this.
Oh, okay.
They have a separate joint jurisdictional meeting for those.
And that's something I suppose we could do.
I know we've-
Couldn't we affect that change, or?
Well, we've talked about it in the past, but I mean, it's formally forming that group, and I mean, you know, you have to get the city and county together, so that's not always easy.
It didn't work the first time we tried it, but you can try it again.
Okay, well, I don't want to send us off on a tangent by any means, but I was just curious.
Well, it's a issue that we keep revisiting, though.
Yeah, yeah, seems like that, yeah, something. Okay.
Would you like me to go over the recommendation again?
Well, staff's recommendation is continue until essentially the violations are cleared up. Is that correct?
And comments are received. Yep.
DOT.
And the DOT.
Yeah.
I would so move that we continue this.
Are we setting a date for the continuance?
Well, we, assuming you get some response, maybe.
Well, that's part of it. Also, without knowing what the specific violations are, the ordinance officer was out all week last week and unexpectedly out all week this week. It's unknown how many violations there are on the property. So that could dictate how long the applicant needs to clean up the property and clear those violations. The applicant is here. We can ask him possibly what he thinks the violations may be and see if he has a comfortable time frame in mind for him.
Oh, okay.
So.
Mr. Morris, have you?
My name is Mitch Morris, and to the current date, I haven't received a violation notice. I was gone also last week on personal matters. From listening to it, the construction yard is in the process of being cleaned up and tore down, and in that process, I have taken down an old trailer house that was, some years ago, was licensed under a trailer house. It wasn't personal or private property or taxed as property. There's various machines that I'm cutting down for iron, there's cleanup, that's in process right now. And that'd be my guess what this might be about.
I don't want to ask him a question, sorry, it's up to you.
Yeah.
Mr. Chair?
Lori.
Do you have a time frame for when you think it might be reasonable to expect those activities?
This is going to be ongoing for the next probably 2 months.
Okay.
We're here. So if we go 2 months out, it'd put us in June.
I'd like to do that further or closer, but yet then deal with any ordinance issues. And the construction yard itself, I believe I can continue this process under a conditional use permit and keep clean the country. But any violations of any ordinances, I would do immediately. So I'd like to not prolong it any further than as soon as we can get to the DOT.
PJ, you get any indication from DOT on response?
No, have not.
Which
is rare. I don't know if it's rare.
In the comment to the cities thing, I have met with the city several times on this, and it's kind of the cart or the horse. They've directed me to proceed with my zoning request, and then in the plating jurisdiction, then I have to comply with all their plating restrictions that comply with the zone. So I'm going to go discuss with them. I'm in the current process with Renner Engineering, Renner and Associates, are starting the work and the survey and all for my plating issues. But that plating has not been applied for yet, kind of waiting on the zoning request.
Oh, that was kind of my question, because like, if the city's, part of it's light industrial, to me, the general commercial is basically lesser use or not as a heavy impact as light industrial may be.
Per our zoning definitions, yes. Yep. And Mr. Morris is correct. This is kind of a cart and horse deal. Sometimes the city does it two ways. They ask the applicant to come in, get the rezone first, and then they go plat, or during the city's platting process, getting rezoned is part of the requirement before the final is done. And I guess in this case, per your conversations, it sounds like they're asking you to do this first, which is why I assume you described the properties out instead of actually having lots.
Correct.
Defined. Okay.
Mr. Chair? Sure. I'm a little concerned about the comments from the Public Works Engineering people that PJ just read about infrastructure to support the improvements. I know we can't put restrictions on a rezone, but could you talk a little bit about what, what your plans are for infrastructure there and what your means are, your resources?
I'll start out by my understanding of the city's requirements. For me to do the lot sizes that I want, they're going to require certain other improvements, whether it be curb gutter, water sewer, whatever. So prior to approving a plat, I'll have to comply with all that. And my intention is, in the red zone, is being general commercial, putting a roadway parallel to the highway as kind of a service road, so most all of the access will be on a service road, not so much highway direct. I have 5 or 6 paid accesses to the highway, that when they built the highway, I took care of that part for my accesses. My intention is to divide that into as low as 3-acre lots in the red zone. But most likely the lots will be bought probably in multiples of 3, depending how the sources will. Put in a paved road that's paralleling to the thing, paved accesses, turn lanes, or whatever is required by the DOT for assisted on-off, additional turn lanes, and then a centralized water system with fire hydrants and stuff like that that meet pretty much the city requirements. Now, since I'm not in the city, I don't have to meet them requirements, but my intent is to build them for future expansion to tie into that. And the problem with that is all developers, is that you don't know what the city requirements were going to be at the time of annexation or attachment. So it's a cart and the horse thing again. Right now, we're in the county, we're within the 3-mile platting jurisdiction. So, but whatever I get a zoning approved for, then the next process is all the platting restrictions that the city will take care of. And then my buildings, as I understand, will be under county guidelines and permits, but yet still within the platting jurisdiction. So I have to kind of comply with 2 entities, but yet one really has the jurisdiction totally in zoning, the county does. But that's the plan on the commercial side. Everything on the opposite side of the highway is presently commercial, general commercial. And I'm trying to comply with that and what am I speaking with the city, and then the intended interest that's in the property. That's what I'm trying to fit to.
Well, I don't know, I guess kind of related to Karen's question, I guess my question is, I mean, there's quite a bit of density there as far as what you have as a master plan there, and I think what part of what the city is saying is they don't have the infrastructure to deliver that volume of water that's needed for that number of houses. So how would you proceed if the city doesn't have the capacity to provide you the water?
This is a phasing concept as well. Right now, I have 2 current wells on the property for a private system. One's almost 400 gallons a minute, and one's almost 200 gallons a minute. I have worked extensively on designing city infrastructure to this property, and the city is really on board with that. They want that. The city needs it, but it's a money thing. Can I fund it all? No. At some point, it's going to happen. The city's future sewer plan goes right through my property for their secondary trunk line out of the disposal treatment plant. And I've been in part in designing that. But the city's also taken that concept and going further with it. It's a money thing, when they can have money to expand, when annexation can happen. It's all timing. I'm trying to proceed with private systems at this point that comply with their requirements in the platting jurisdiction.
My concern there is if the city doesn't have the capability to serve you, you may have wells, but then you're going to get into the state rules as far as small community water system and the financial and reporting requirements and.
Yes, I understand all that.
Okay.
Plus, there are issues with that many septics. That would
Yes.
be an enormous.
I'm aware of that, and right now it depends on how the approval goes and how the phasing aspects goes. We're looking at a sewage treatment plant on site right now.
I would say the lot size wouldn't support a septic system.
It would have to be a community system.
Other questions for Mr. Morris or PJ? I think, Jim, you started with a motion to continue.
We were trying to decide a time or a date.
Oops,
What,
just close that.
June or July or?
Might even be
Is-
earlier than that.
Is there a process where, maybe I'm speaking out of turn here, but that I can contact the DOT to push that, find that time frame on that, so we can plan a meeting?
Yeah, we don't discourage that. We just, whatever they do, we just need it in writing with their letterhead, and
Okay.
we'll do it at the same time. Also, whatever date we choose, we could also add a caveat that if information is received prior to that, that it goes on the next available planning commission meeting.
Yeah.
Okay, so right now, we're the 13th, we could, I'd say we try 27th, April 27th?
Yes, please.
Be the next planning commission meeting.
Okay.
Did we have a second motion, or that was your motion then?
That was my, yeah, the 27th, is that what you said?
Yeah, that would be the,
Yeah, second.
A motion and second. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Aye. Opposed, same sign. Motion carried. Item 18.
Get that one up here. Item 18 is rezone 1503 and comprehensive plan amendment 1503 to rezone approximately 424 acres from general agricultural district to suburban residential district, and to amend the Pennington County comprehensive plan to change the future land use from limited agriculture to suburban residential. So the applicant is Mitch Morris. And for this portion of the applicant's proposal, he's looking to basically subdivide 5 existing lots into 11 new lots. All but one of the existing lots appears to be vacant of any structures. One of the lots in the bottom right corner, right here, doesn't come across in this aerial, has a aircraft landing strip conditional use permit that was approved in 2011. The lots that Mr. Morris is actually looking to have created vary in size from 9.86 acres to 54.96 acres. The further subdivision of those lots would be done through the city of Rapid City, as it's within, this is also within their 3-mile plating jurisdiction. As far as conditional use permit 1115 is concerned, on March 30th, I contacted Mr. Morris to inform him and remind him about the conditional use permit that existed on the property, and that the conditional use permit for the aircraft is not an approved or listed conditional use in suburban residential, and there is a very high possibility of that conditional use permit being revoked or ending if this rezone was to take effect. On March 30th, I also contacted the applicant of the conditional use permit to inform him of this effect, which is common practice in our office. The applicant stated he was unaware of the rezone request, and that he would be contacting Mr. Morris. Whether the two of them have talked at this time, I'm unaware of if that has happened. Maybe that could be cleared up by the applicant. There are proposed at all phases of this construction approximately just over 2,500 lots. And again, these would all be platted through the city of Rapid City. This rezone request and this comprehensive plan was also routed through all our regular departments, and the same concerns came back for this rezone and comprehensive plan request as came back for the one you previously just heard. The future land use for this property, it's currently general commercial, and the future land use is limited agriculture, and he's asking to go down to suburban residential to be able to build possibly future Morris Ranch subdivision. Is that the name? Morris Ranch? Okay. So without taking any extra time, it's pretty much the same concerns as the last one. With the lack of comments coming in, again, from the South Dakota Department of Transportation, also, staff has just learned receiving the certified cards from the applicant this morning, that one of the cards actually was not mailed to the right address, probably a simple mistake, but the provided address that the office gave him was P.O. Box 5543 for Magerhorn LLC, and it actually went to PO Box 5544. So essentially, this person who was supposed to receive notification did not. So for that reason, and also that the comments have not come back from the South Dakota Department of Transportation, staff is asking that this be continued. And Jerry, would the 27th have enough time for the mailing to go out? Could we get one prepared in time?
Yes, if it's sent out by Friday, this Friday.
So staff recommends continuing rezone 1503 and comprehensive plan amendment 1503 to the April 27th Planning Commission meeting.
Mr. Chair, I'll make a motion to continue RZ 1503 to the 27th of April.
Second.
We have a motion and a second. Any further discussion? Mr. Morris, did you wish to comment on anything on this one?
The airstrip that we have approved, it's jointly with an individual called named Roger Larson, or excuse me, Roger Johnson and myself. And it's just a place in my pasture that's a grass runway, and it's being utilized by two entities, the remote control airplane group that I donate and let them use it, and then the same I donate to. Mr. Johnson flies the banners around town, have you seen? And the city airport wouldn't let him do it there. I'm an aviation enthusiast, so I just let him use the ground, and if this gets approved, we'll move it to another location. It's not an issue for us.
Okay, thank you.
Pull it up.
Motion and second, further discussion? Hearing none, all in favor, signify by saying aye.
Aye.
Aye, opposed, same sign, motion carried. PJ, County Board Report.
Board of Commissioners concurred with the Planning Commission's recommendation from the March 23rd, 2015 Planning Commission meeting.
Items from the public, we still have several members of the public here. Anyone wishing to speak? Hearing none, we'll move on to the next item. Items from staff, building report.
Item A, building permit report. You should have everybody have copies of the most recent one from March. Essentially, items of note, single-family residents are up 47% over this time last year, 17 total last year, and 25 year-to-date for this year. Also, item category 328, which essentially sheds and barn, is up over 62% over this time last year, and overall, our building permit reports are up 21% over this time last year. Keeping us very busy.
Sounds like things picking up.
They are picking up. Ready for B?
Yep.
Item B, just a quick update on Vacation Home Rental Committee. We are meeting on Thursday. I know Tomovic had mentioned Friday. It's actually this Thursday, the 16th at 3 p.m. in the Planning Commission, the Planning Department's conference room. Items of note from the last meeting, the chair is Charlie Johnson, the vice president is Rita Chapman, and the secretary is Jim Peterson. There is also a link on the Planning Department's website that's listed as vacation home rentals, where they're going to post agendas and minutes from their meetings, and then any additional information that the committee finds to be important. Nothing further.
Okay, thank you. Items from membership?
But on the Vacation Home Committee, you already know who's on it. The agenda on the first meeting just covered business stuff. Items for the next agenda will be to review of the ordinance, including any complaints, and number of applications, including the number approved and denied, how many sold with no transfer of VHR, list of health licenses issued by state to Pennington County, and a request to the Planning and Zoning Department to keep a phone record and desk record of any requests, which this is really heavy on the department, I'll tell you. Review process of Planning and Zoning Commission actions was another thing that will be done. Legal oversight will be reviewed. Grandfathered properties will be reviewed, and how the ordinance is working for those affected, owners, neighbors, visitors, operators, managers, et cetera, will also be on the agenda. So, and then there's a
Busy.
future agenda, but I'll address that
That
later.
sounds like an ambitious agenda.
Yeah, it is ambitious, but I think probably needed.
PJ, do you have a comment, or you?
Those are definitely items that were talked about last time. Charlie hasn't submitted the official agenda for posting yet, so some of that may change, I don't know, but she covered the discussion of the committee very, very well.
How many days are you meeting?
Every week
No,
is
I
what they're
mean-
looking at, you know? Oh, don't know.
Other items? I guess I had an item if no one else has. I guess one question I have, and probably the wrong time to ask it, given our packet this time, but I know at one time, and I'm trying to remember, PJ, it was before you were on board or not, but Dan had talked about possibly moving up the mailing date to get the packets out a day early. And I mean, like, you know, even for us to review this, but I mean, like, for the applicants, we've heard several times, and Mr. Evangelisto had commented to me, I mean, you know, they're not getting almost time to react, because you're going into a weekend and people are gone, and you know, so sometimes it seems hard to prepare or gather information you need to come here at 9 o'clock on Monday morning. I know that's, staff has already pushed, and like when I get a thick packet like that, I know you guys are probably scrambling to get that out, so I don't know if that's even doable, or what has to happen to change.
Yeah, the volume of reports that have come into this office, at least in the last 6 months, I'd say, I mean, the staff is taxed to the limit now, the vacation and rental committee pulling staff away and things like that. Staff has actually even talked with the commissioner's office and seeing what we can do to restructure or improve the submittal process. I mean, as far as scheduling, you know, staff, just time management, but you know, there's always a priority that comes up at the last minute that takes precedent over everything else. The other thing is possibly changing the submittal deadline dates. Right now, we're at minimums. We could push it back a little bit, which would require more time for an applicant before their item is heard before either the Board of Commissioners or the Planning Commission. So there's options that we have talked about.
Well, and for the applicants, I'd hate to see us drag out the timeline much any longer than we do already. Karen?
We consider moving the planning commission to, say, Wednesday morning, since we're not in conflict with courthouse anymore. That would allow us more time, you know, if you sent us the stuff on your same schedule, but our meeting were just a few more days into the week, that might also give, you know, the public who wants to comment to us.
Require
more
change in the
time.
bylaws, which would probably be pretty simple.
Yeah, because I think it's defined as Monday now, isn't it?
Yes.
It is.
Yep.
I guess
Or
my
as needed,
comment
yeah.
would be not a Wednesday, a Thursday,
Not a Tuesday.
not a Wednesday. Wednesday's a bad day.
We can put it on as a discussion item and
It may be worth doing that. I mean, we've heard that several times, you know, the applicants are coming in here just barely receiving the notice, and, you know, and then they're trying to throw information on the dais at the last minute because they didn't have time to get emails or something out too, so.
Yep.
I think we could just be more responsive to the public, but I mean, I know you guys are stressed already right now.
Yep.
One of the things that maybe consider, and I don't know what we'd have to change to do that, but some of these conditional use reviews, to me, could almost be administrative. I mean, that there's no discussion, it's, you know, a very quick motion, you know, even to the point of does it really need to be on the consent agenda? You know, that takes away you from having to write a report and all that, you know, just, I don't know what that does for you guys, though.
Well, I think something would still need to be written up, maybe at least a memo for the file or something. I personally wouldn't be against it. I know the previous director has stated several times when he was here that he would, you know, the fewer things that can come before the Planning Commission, the Board of Directors, or the Board of Commissioners that can be made administrative, he would be in favor of that. I don't know, I don't remember any official action that he had taken on that. But as far as making that official change, I would want to talk to the state's attorney's office first, and I don't know if it would have to go through the Board of Commissioners for final approval to change that process. I'd want to look at state law a little closer.
Well, and I guess my thought would be is like, you still may do a 2-year review, but it's administrative and it's not necessarily, then you don't have to, you know, if everything's in order, then you don't have to write a report to give to us to put in the packet, you know.
Oh, I agree.
And
Yeah.
it just, for the items that are important that we know that are going to take a lot of discussion, gives you more time for that, is more responsive to the public.
I'd be in favor of that, absolutely. As long as it's approved, yeah.
But ultimately, you've got to save staff time, like visitations and that kind of things to the sites and so forth. I mean, those are the kinds of things that must be horrifically time-consuming in addition to, you know.
Not enough hours in a day. We need more staff, so if anybody wants to make that recommendation, I could take that to the Board of Commissioners. I mean, we're essentially working with 3.5 planners, everybody, you know, and everybody's stretched. And,
You want to get rid of half of them, or?
no. No, I need to add more, 2 more planners and somebody else for wastewater systems.
Well, you know, along those lines, do you have to even have a 1 or 2 year review?
I'm sorry?
Do you have to have a 1 or 2 year review? Why don't you just have it upon complaint? Your office could be the complainer. I mean, you would still probably have to have a 1 or 2 year
Internal
internal review of what's going on, but you wouldn't necessarily have to involve the planning commission. I don't know. I mean, maybe there's another reason to do that, but.
But, yeah.
Yeah, everyone unfortunately is different, and it's pretty much up to staff when they're looking at it. We try to keep with, you know, if a conditional use permit is a brand-new one, it's usually 1 year, just to see how they're doing, because it's new for them, and it's new for us, that specific use. And then, usually from that, it can go 2 years, 3 years, 5 years. I have no problem with changing it, or looking at changing it.
It's like the one today with the caretaker residents, you know? You call them up on the phone, hi, is grandma still alive? Yep, okay. I mean, you know, that's pretty.
That's essentially how it is.
Yeah.
Oh, that's so typical.
We're a little more eloquent than that.
Well, and the one today where you did remove the review, for the cemetery?
Yeah.
You removed the years. It was just reviewed on a complaint basis, so it was deemed necessary.
We removed it, it was actually
Yes.
requests.
Yeah.
to be removed,
I mean,
yeah.
sometimes I don't know if it's gonna save you any time, other than writing a report for the commission, but, because you're still gonna have to go out and look at them, eventually.
Yeah.
You know, maybe have some computer ticker that says, you better get out and look at this place, but.
I mean, from my experience, I would say that there's some you wouldn't want to do just on complaint. You'd actually want to set a time. So that we have.
Forces them to do something.
I mean, because we don't want to come across as, like you had said, we could review it on our complaint, but we don't want to come across as badgering them or harassing them just to file a complaint to review it. You know, if there's a set time, then we just go out there.
Yeah.
You know, so that.
Okay, yeah, that's
You
the
know,
other
so-
side of the coin.
But you kind of know which ones are going to be problematic, not. So. I mean, just by the importance of the item, action being taken. Anyway, anything else from membership?
I just had a reminder, I'll be gone May 11th. Just want to remind you.
If not, I entertain a motion for adjournment.
So moved.
Second.
All in favor, signify by saying aye.
Everybody wants it.